All right. Well, I see everyone here at 6 o'clock, so I'm going to call the Sandy City Council work session to order. Jeff, will you call the roll?
Yes, Councilor Petzold.
Here.
Councilor Smallwood.
Here.
Councilor Sheldon.
Here.
Councilor Walker.
Here.
Councilor Exner.
Here.
Councilor Hokanson.
Here.
Mayor Pauline.
Here. All right. I'll start off with a review of tonight's meeting, and I'll pause on each area just in case somebody has a question that they want to provide to staff or some kind of commentary. Changes to the agenda. Is there going to be any proposed changes to the agenda tonight? Any questions about it? All right. We will then have a presentation on our recent year-end audit. Any questions or comments on that before we get into it? Then under our consent agenda, we have our City Council meeting minutes from February 1st, as well as the renewal of the Oregon Public Works Emergency Response Cooperative Agreement. Any questions or comments on our consent agenda? Don.
Hey, just Jeff, you shared with me earlier today about the plan for the Urban Renewal Board's future agendas. Can you want to just brief everybody on that?
Yeah, thanks for bringing that up, Councilor Hokanson. So Councilor Hokanson asked me why the February 1st Urban Renewal Board meeting minutes are included on the consent agenda, but not the ones from the special meeting that followed 48 hours later. The answer to that question, just briefly, is historically our practice has been for the City Council to just go ahead and approve those minutes as a combined document. But really the proper process would be to handle them separately, with the Urban Renewal meeting minutes reviewed and adopted by the actual Urban Renewal Board. So that's what we plan to do going forward. This is just the last time it's being handled under the old system. The February 3rd meeting minutes you will see on the next Urban Renewal Board meeting, which should be March 1st, if that makes sense.
Perfect. Kelly O'Neill, you're unmuted if you don't mind muting, or Jeff, if you can help take care of that. Perfect. Okay, so then under old business, we have our Planning Commission appointment. Is there any questions or comments on that before we do it tonight? Okay, and then under new business, we have a public hearing on the views plan development. And Don, did I see a hand up in the corner of my eye?
Yeah, we can talk about it later or now, but one of the thoughts I have is on the interview process. Do we provide written questions for those interviewees? And in the future, if we don't, should we make it more of a written interview? And we don't have to talk about that if it's better to talk about that later. But
yeah, I mean, I think probably most of our dialogue should probably be later in the agenda. I will answer though that there's an application that they fill out that we get some answers to, normally teamed with a resume. And then we have questions that are about 11 to 12 questions that the panel asks, and we kind of rotate through those. And we ask the same questions to every single candidate. I know there was a little bit of an email exchange on one of the candidates this last time around, having served on the panel previously, that they may had a little bit more of a window, obviously, into what questions would be asked. So I'm sure that will be open for discussion tonight, but that's normally the process. I'm open to any other process in the future.
Thanks.
Yep. All right. Any other questions on the Planning Commission appointment process? Okay. Then under new business, we'll have our public hearing on the views plan development. Is there any questions on that before we jump into it tonight? Great. We'll then go to our report from the city manager and then our committee and council reports, and we'll adjourn for the evening. With that, we'll now go into our topic for our city council work session tonight, which is public meetings, ethics, and land use hearing training. Chris Crean, hope I said that right, I believe is here for the presentation.
Thank you, everyone. For those who don't know me and I haven't met, which is basically everybody on the planet since last March, I am Chris Crane. I've been with Barry Elsner for 15 years and have had the pleasure of working on Sandy issues periodically over that time, and Kelly and Jordan thought it would be a good idea for me to do a quick training on some land use procedures, specifically what we call quasi-judicial procedures, because you've got some coming up. And land use is really a very rule-bound world of its own. And these kinds of hearings have very specific, very particular rules. So we thought this might be an opportunity to go over some of them ahead of time. And then once the idea had been broached, mission creep set in, and we decided, well, let's also talk about public meetings and public records. And then the last one was, well, let's also talk about this other statute, 197-522, about what options the council has at the end of it. So there's a lot of stuff to go over in about 45 minutes. So I'm going to go fast. I'll try to cover the high points of things you need to know. And I encourage everyone not to wait till the end to ask questions, but jump in if something pops up that you really need an answer to, because by the time we get to the end, you will have forgotten. And so jump in if you have a question.
Chris,
yeah.
may I just say to council, usually you guys are really polite and raise your hands and stuff to speak up. During these presentations, usually I can't see you. So during the presentation, I mean, just feel free, obviously, pitch in with any question.
Right. We sent, I think everyone got this document, land use training materials. It's really dense. There's a lot of stuff in here. And I'm not going to go over it all. There just isn't time, and you don't really need to know it for tonight. But if you really like land use stuff, this is a good place to start. The other thing about this packet of materials is it's somewhat dated. We put it together about 10 years ago. And it really needs an update. Particularly recently, the legislature's been very active in the area of housing specifically. And there are some new rules that have come out that affect a city's options and what it can and can't do. Again, specifically in the area of housing development. And so we plan to update these soon, and I'll give you the verbal update. But if you do this training again a year from now, these materials will be different. But just take it home. It's a useful thing to have if you ever have any land use questions. Between that and Kelly, you should be able to get your questions answered. So I'm going to jump in, and I see on the agenda the question was, or one of the land use aspect is just called land use hearings training. And so what is a land use hearing, a land use decision? I'm going to jump in the middle and swim out in both directions at the same time. So there are two kinds of land use hearings that you will that will come before you at some point, presumably if you're on the council for more than a week. One is legislative and the other is quasi-judicial. The Parks or the Views PD later tonight is a classic example of a quasi-judicial. It only affects one property. The distinction is a legislative hearing deals with making law or policy for the city, whereas a quasi-judicial hearing deals with applying those laws or those policies to a specific person or property. So one is making laws and the other is applying those laws. There was well, I'll give you an example, a couple of examples of legislative. I think it was a year ago or so, the city did some updates to its annexation code provisions. Those, the classic legislative example of legislative decision-making, those changes to the development code will apply to every annexation in the future, right? And it involved a lot of policy discussions. Do you have different rules for big annexations versus small ones? Do you waive the application fee for some? What about natural resource assessments before a property is allowed to annex? Those kinds of things are policy decisions, and they get distilled down into a law that applies to all annexations in the city going forward. Another example, I know we did some recent changes to your sign code, right? And so now all updated the code, and now all those updated policies and code provisions apply to all signs in the city. There was a case about, I don't know, 30 years ago or so, an Oregon Supreme Court case that set down some criteria for how to decide when a decision is legislative versus quasi-judicial. And I'll just very briefly, the first is whether the decision being made will apply to a large number of properties and people, or just one or two properties, or one or two people, a small number of people. Well, changing your annexation code applies to everyone, right? Large number of properties, large number of people. Dealing with an individual annexation application, that's dealing with an individual property or person. So that's the first thing you look at. If it's one person or property, it's probably quasi-judicial. If it's a large number, it's probably legislative. 2, are you restricted to a pre-existing set of criteria or laws in making your decision? Or can you exercise independent policy judgment? If you can exercise independent policy judgment, it's probably legislative. If you're stuck with applying the law as written, it's probably quasi-judicial. And then 3rd, are you bound to make a decision? For legislative decisions, you could always table the matter, right? You can decide, excuse me a second. Of course, I'm the one guy who didn't silence his telephone. If you have to, so if you can table that, you decide, okay, this annexation thing just got too complicated. We have other things that are higher priorities. We're going to set it aside. If you can set it aside, it's probably legislative. If you have to make a decision, it's probably quasi-judicial. Now, none of these are determinative, and you have to weigh them and balance them, but those are the things you look at. All right, so the other important thing that may not have jumped out at those criteria at you is this is quasi-judicial with an emphasis on the judicial part. You're basically acting as a judge in a quasi-judicial proceeding. You have to apply the law as written. You cannot make independent policy judgments. Policy decision-making is for a legislative process. It's not for individual. You do not, I'll guarantee none of you want to walk into circuit court and have your property rights or your divorce or whatever you might be going to circuit court for, your contract matter, decided on a policy basis by a judge who thinks he or she knows what the right outcome should be. You want the law, the case to be decided on the laws that are on the books. And the same rule applies to city councilors in a quasi-judicial proceeding. Your development code is full of criteria. Staff has gone through the code and figured out which one applied to that application, that development project, and applied them and made a recommendation. You have to decide whether if the staff is correct, but you're stuck with those criteria, the criteria in your development code. You can't deny a project because you don't like it or because of its effect on property values or other reasons that are not set forth in the criteria. In a legislative proceeding, you absolutely can. And in fact, a lot of you are elected for your biases, for your preferences, for the policies you want to pursue. And in a legislative proceeding, you're expected to bring those to the table. In a quasi-judicial, you have to set them aside. And the one example I continue to turn to is, gosh, almost probably 20 years old at this point, but there was a guy named Rob Drake who was the mayor of Beaverton, and Fantasy Video adult shops was applying for a conditional use permit to open a store in one of their commercial zones. And he said on record, and he was later challenged for bias, and Luba said no. He said in the minutes, I don't like this use, this applicant, I don't like the application, I don't like the use, but I don't get to make that decision. I have to put on my other hat tonight and make a decision based on the criteria in our development code. And that's exactly right. It doesn't matter whether you like the use or not. Your decision, it has to be based exclusively on the criteria in the code. And if you want to deny something, you have to be able to point to a criteria that you think the applicant has not met and why you think it hasn't met it. And at this point, there's going to be just, probably thousands of documents in the record. And so you have to decide whether you think, well, I'll get to the next one. Your options are, you can approve an application if it meets all of the criteria in the code. You can deny an application if it doesn't, and you can approve it with conditions. And that's frankly 99% of the time what happens. If an application is approved, it's usually approved with conditions because your code probably has criteria that require things like sidewalks and curbs along the frontage of a property. Well, if it's not developed yet, it clearly doesn't meet that criteria yet. So you add a condition that says that before the issuance of building permits or certificate of occupancy, the developer shall build the frontage improvements. And as conditioned, then that criterion is met. So you can either approve with conditions, or deny. Those are your options. In terms of looking through all that evidence and reaching your decision, it's important to keep in mind that at every step in the local process, the applicant has the burden of demonstrating that the application meets the criteria, right? They're the ones seeking the permit. It's their application, and they have to demonstrate that it does. And if it doesn't, you have to deny it. So it's a little counterintuitive, I think, for some folks. If an example is tonight, for example, that the Planning Commission approves a project and it gets appealed. So it comes up to the City Council. Well, who's got the burden? Does the appellant have to show that the Planning Commission got it wrong? No, they don't. The applicant still has the burden, both before the Planning Commission and before the City Council, to demonstrate that their project meets complies with the criteria, either directly or as conditioned. So one of the procedural aspects of that rule is that means the applicant always gets to go last. And I think you'll see that in the script tonight, in the proceedings tonight. The applicant gets to go first. They make their case, why they think their project complies with criteria. Then the opponents will get up and try to persuade you that it does not, by reference to evidence in the record, hopefully. And then the applicant always gets to go last because it's their burden. It's their application, their permit. They get to the final bite of the apple, the final word on the subject. And then you can close the testimony portion of close the record for testimony, ask questions of staff, and deliberate and make your decision. It's important, critical really, to keep in mind that, again, your decision has to be based on the criteria, and there has to be evidence in the record that demonstrates the criterion is met. I can't tell you how many LUBA decisions are out there that have rejected a decision and sent it back for another hearing, further proceedings. If all the findings say is the criteria requires that the property, the developed projects or structures be set back 20 feet from any wetland areas, and then the finding is all of these are set back 20 feet from the riparian areas, this criterion is met. Well, how do you know they're set back 20 feet? Is there a plan set in the record? Was there testimony from someone? You have to be able to identify the evidence that allows you to reach a conclusion. So that's really the test. You identify the criteria. You can say, well, this traffic study or this engineering report or this riparian analysis shows that the criterion is met. Therefore, we find the criterion is met, and you move on to the next one. There are dozens, at least dozens, probably scores of criterion in this kind of application, and you just have to do the homework and go through and read the criteria, look at what evidence staff relied on, their applicants relying on, or the opponents relying on, and to decide for yourself what you find persuasive. There will occasionally be times when you have to weigh conflicting evidence. If you've got a wetland area, the applicant may have provided a delineation that shows that it does not extend to a certain part of the property, and then opponents will come with their own wetland delineation that shows that it does. So you've got a battle of experts, and you have to decide, just like any judge in a courtroom, which witnesses do you believe and why? Which witness do you find, which traffic engineer do you find compelling? Which traffic engineer do you not? This will often come up, for example, if the applicant provides a traffic study that shows there's that crashes at a certain intersection fall below a critical level or measure. And the neighbors will come out and say, there's crashes at this intersection all the time. Well, and is anecdotal evidence more compelling than a traffic study? You have to decide. That's your job. You're the judge, and you have to decide which witnesses to believe. I want to talk, so that's general, I don't know how to be any clearer on your role, right? You're an impartial, the sort of lodestar of all of this is every applicant is entitled to an impartial decision based on the evidence in the record and the criteria that apply to that project. If you can't be impartial, we'll come back to this, you can't be impartial, you shouldn't be sitting in on the hearing, right? And that's up to you to decide. The final sort of broad discussion of some things that apply that are different in legislative versus quasi-judicial are bias, ex parte, and conflict of interest. And they're different depending on whether what you're doing is a legislative decision or a quasi-judicial. Starting with legislative because it's easiest. You can be as biased as you want in a legislative proceeding. If you don't think convenience stores should be allowed in the C2 zone, well, then when the C2 uses in the C2 zone comes up, You can say why that is. It has nothing to do with criteria. You can make policy-based decisions. Are you pro-growth? Are you anti-growth? Do you want to keep development near the schools, away from the schools? What about commercial hubs and their proximity? Do you want to step down development back from view sites? I mean, all of those policy decisions, once you, the annexation amendments, for example, how do you handle wetlands analysis or natural resource area analysis in an annexation context? It's a very policy-based decision, and you bring your biases to the table when you make those decisions. In a quasi-judicial proceeding, you absolutely cannot be biased. And if you are biased, it doesn't matter if the decision was 7-0. LUBA will send it back, and you get the opportunity to recuse yourself and have the city council go back through the whole hearings process again and reach a new decision without the bias. Bias I will say though, however, bias is a very high threshold to be able to show bias. One of my favorite examples is out of Jacksonville. The Jacksonville church was applying to have an addition built on it. And one of the planning commission members was a member of the church and was ultimately challenged for bias. Maybe he was city councilor. And Luba said, look, the fact that somebody might also be a member of the church who is the applicant does not mean they can't set that bias aside and be impartial in reviewing the evidence and the criteria in the record. Rob Drake went on record and said, look, I don't like this applicant, I don't like this use, but I don't get to make that decision. I have to set that aside. So two things about bias. If you think there's any question in your own mind or in anyone else's mind about your bias, get it out there. Just disclose it at the beginning of the hearing. You'll have an opportunity tonight when I assume it's the mayor reads the script, you'll have an opportunity to declare any bias, ex parte communication or conflict of interest. Just get it out there. Say, I understand the perceptions, but I'm not biased. I can be objective. I can be impartial and review the evidence and the criteria and make an impartial decision. Just get it out there. So actual bias is always poison to a decision. It will cause it to come back, but the threshold is pretty high. Ex parte communications, because you're acting as the judge, everybody in the room, all of the parties are entitled to know what you're basing your decision on. What information are you getting? Hopefully it's all in the record, or, and people will come before you and testify. So you've got written evidence, you've got verbal evidence, and your decision is supposed to be based on that. If you're getting other evidence, like emails from someone that are not part of the record, if you're having conversations with somebody outside the hearing room about something that's pending before you, if you're reading social media, if you're engaging in Twitter or other social media discussions about something pending in front of you, all of that is ex parte communication because it's not in the record. And you can do that. You're expected to do that in a legislative proceeding. You can and should talk to everyone who's interested in any setting when making a policy decision, when deciding what are the laws that are going to apply to us here in Sandy. But in a quasi-judicial context, people are entitled to know what you're basing your decision on and what the evidence is that you're hearing. So if you get email, if something's pending in front of you and you're getting email on your personal email or city email, forward it to staff. They will print it, put it in the record. It becomes part of the record. Once it's in the record, it's not ex parte anymore. But if somebody stops you in a grocery store and wants to bend your ear, or you're at the kids' soccer match and somebody wants to talk to you about a project that's going on, or in any other context, or social media, at the next hearing, you're required to disclose those communications. All you have to do is at the beginning of the hearing say, yes, I talked to so-and-so. They wanted to tell me why this was a good project or a bad project. Get it out there, and then it's on the record. It's not ex parte anymore. If LUBA finds out that there was an ex parte communication, they will send it back, make you disclose that ex parte communication, and do the hearing all over again. It's really painful and expensive and a waste of time. The cheapest way to insulate a decision from a challenge based on ex parte communications is just to disclose it. It's the cheapest insurance in the books. The final thing is conflict of interest, and you may have had some training in conflict of interest already from LOC or from other folks, particularly if you've been on the council for any period of time. But there are two types of conflict of interest. One is an actual conflict, and the other is potential conflict. And the difference is will versus may. So if your decision will have a financial benefit or detriment for yourself or somebody in your family or your business, or the business you're associated with, if it will have a beneficial or negative effect, it's an actual conflict of interest and you cannot participate in the decision. You should just note your conflict at the beginning of the hearing and step down and let the other folks take it from there. If it's a potential conflict of interest, this test is whether it might have a negative or positive effect on you, a family member, business you're involved with. And an example of this that comes up often, frankly, in our land use context is realtors. Realtors often serve on planning commissions. Well, if you approve a subdivision with 40 new lots, there's a chance that realtor could end up selling one or more of those lots. But it's speculative. You don't know whether you will, and it's speculative. You don't know whether you're going to have it, but you might not. So yes, Councilor Exner.
I let it slide a little bit because I thought you were going to talk about more, but go back a little bit to when a person has been identified as having a conflict of interest. We've had an example here a while back where a planning commissioner was identified as having a conflict, and they removed themselves from the diadem where they were sitting on part of the planning commission, but they sat back into the audience. And there was conversations going on. Just how far do you separate yourself from the conversation and decision once you've identified that you're have a conflict?
If you've identified that you have a conflict that is significant enough that it prohibits you from participating, you can absolutely sit in the audience and watch. If you're on the planning commission in the first place, you probably find this stuff interesting. I have no problem sitting there just watching and seeing what goes on. You should not testify, however, right? Because that's going to lead to, if not allegations of bias, people are going to start sniffing around for ex parte contacts. Is this planning commissioner talking to his or her colleagues offline? Don't testify. It's just going to create ambiguities that will cause legal problems down the road. So you can absolutely sit there and watch, but you should not participate. And the same thing's true at the city council.
May I just interject though, as council, we do have a council rule in our council rules, and Jeff, tell me if I'm wrong, that if you do declare that you have one of these biases or conflicts that makes you step down, you should leave the meeting room. Our planning commission is not bound by these same council rules, so that obviously does not pertain, but my understanding is we do have a council rule that one should leave the chambers if they declare themselves with such a conflict.
And you must always follow your council rules.
Yeah.
That's
Yeah.
a no-brainer, right? Those are rules you get to set for yourself, so those should absolutely be followed. With a potential conflict of interest, you don't have to step down. You can still participate in the decision, but you do have to declare the potential conflict, right? So those rules apply equally in either legislative or quasi-judicial proceeding, right? So those will come up. In fact, those frankly apply to every decision you make as a city councilor, every formal decision. But in a land use context, yes, Councilor Walker.
Unmute. Thank you. Hey, I just have kind of some questions about certain situations that we have regarding just what you're talking about right now. And I just want to throw these things out to kind of, first of all, get clarification. And second of all, just kind of understand also your thoughts on, you know, what I understand is there's actual conflicts of interest and then there's perceived conflicts of interest. Mm-hmm. And so, you know, like you were talking about the realtor situation, you know, that's obviously you can't speculate as to whether or not you're ever going to get, you or your real estate business is ever going to get a commission on those houses. But there's perceived conflicts of interest. So one of the things that came up is that my husband is the public works director. And so I understand from what I've been told at the League of Oregon City Ethics folks was that that if I'm, you know, if we're talking about the budget as it relates to his salary, I would be recusing myself, obviously. How, is there any other aspect to that you see as a conflict of interest for me?
The only one I can think of in this context would be if the city were building a new public works building and that application came before the city council. I have a hard time seeing how, just as an employee of the public works department, it would present an actual conflict, right? Maybe he gets a nicer office, but I don't think that's what the ethics rules have in mind. In fact, in order for it to be a conflict of interest, it has to be what the statute calls a pecuniary interest, so a financial interest. So I don't think Public Works building would require you to recuse yourself. That said, it's really important, and you guys know this, to keep perceptions in mind, right? People want to believe that their city council is being forthright with them. So if the perception is out there, just address it at the beginning of the hearing. Say, you know, I have a potential conflict. My husband works for Public Works. This is a new building for that department, but he's not going to benefit or suffer either way. So it's probably, he probably isn't. And if he does, it's speculative. So it's nothing more than a potential conflict, but I did want to get it out there, at least address it, right? So that people. Yeah.
So if we're talking about like the size of pipes or things like that, changing the code regarding sewer pipes and things like that, that's not a conflict of interest.
Correct. I mean, all of those are legislative decisions.
Yeah.
Right.
And then
yeah.
Regarding kind of, you know, we sit on different nonprofit boards in this town. And the city council makes decisions, we, you know, actually sit on the boards of these,
Right.
you know, whether it's the Community Action Center, the Chamber of Commerce, Ant Farm, all those great things. And obviously it's a wonderful thing that we do, that we're able to kind of take our personal time to do that because it's so important. But when we're allocating city funds to these nonprofits, for me, it feels like we should be kind of recusing ourselves, because even though we're not personally benefiting in our bank accounts, obviously, the board, you know, and nonprofit that we're kind of representing in other capacity is financially benefiting. And so can you kind of speak to that? And, you know, is that an actual conflict or a perceived conflict, or how can we kind of try to pass the smell test on that front? Because it's so important that we're able to
I don't think it's a conflict of interest at all, either way, not under the state statutes anyway. Again, the state statutes make a distinction about whether you will or may enjoy a pecuniary benefit or suffer pecuniary loss, which is financial. So if you're not paid and you don't have a family member that works for the Boys and Girls Club who is getting a $10,000 grant, then you don't have a conflict of interest, even if you sit on the board.
But you could see, like, if the nonprofits that didn't get the grant, you know, you could see where they could kind of come back and feel like, well, they got the grant because, you know, one of the council people was on the board.
Yes, absolutely. And that's likely to happen. And every nonprofit wants their champions on the city council. You know, that's politics, and people get elected because of their engagement in the community. But it's not, unless you're going to, there is an actual or potential risk of financial harm or financial benefit. It's not a conflict of interest, either actual or, and frankly, I think folks need to be upfront and just out there with those biases. There's a reason you sit on the boards of various agencies, because you believe in their mission, right? And there's no reason to be shy about that, I don't think.
Thank you. I think that's all I had.
Okay, so bias and ex parte apply in a quasi-judicial proceeding. If you've had any discussions about the views tonight that are not in the record, make sure you disclose those at the beginning of the hearing. Conflict of interest applies equally to legislative and quasi-judicial. So that's the take home there. I do want to, before we start running out of time, touch on some of the important rules that you need to keep in mind. One that if you've been doing this for any amount of time, or if you served on a planning commission, you know about, is called the 120-day rule. The city must issue a final decision on a quasi-judicial land use application, on most quasi-judicial land use development applications, certainly, within 120 days of the date that application is deemed complete and by the planning department. That deadline can be extended, but only by the applicant as a general rule. So yes, Councilor Walker.
So does that include zone changes and planned developments and things like that?
Yes, it does. It concludes both of those. The statute uses the phrase, three terms. It applies to an application for a permit, limited land use decision, or zone change. And a permit is the discretionary development of land. So a planned development is a discretionary development of land. A zone change is a zone change. A limited land use decision is a subdivision. So anything that involves actual development is probably subject to the 120-day rule.
Because
I'll give you an
well,
example.
like Bull Run Terrace though was a comp plan change, and that we were told that that wasn't 120 day.
Right, sorry, that's
Okay.
correct. That's one of the exceptions. A comp plan amendment is not a zone change. It might result in a zone change, but it's not a zone change. An annexation decision is not a permit, limited land use decision, or zone change. A sign code, changes your, so there are some land use applications, quasi-judicial land use applications that are not subject to the 120-day rule, but by and large, anything that requires front-end loaders to get out there and start moving dirt around is probably going to be a quasi-judicial permit decision and subject to the 120-day rule. Again, it can be extended, but only by the applicant, with one exception I'll get to in a minute. The other, one of the other rules that's important to keep in mind is called the fixed goalpost rule. And that says that an application is subject to the criteria that are in effect on the date it's submitted. Even if those criteria change while that application is in process, the new rules do not apply. Fixed goalpost. And again, that one applies starting on the date the application is submitted, not the date it's deemed complete, for those who are taking notes. The one statute that Kelly wanted me to mention tonight is an exception to the 120-day rule. And that's one, that statute is ORS 197.522. And it says if a city or county is about to deny an application, you have to give the developer a chance to address the criteria, the reason for the denial, and potentially propose conditions that might allow it to be approved. It might allow it to meet the criteria. So at the end of the day, if it looks like the application is about to be denied, you ask the developer, do you want one last chance to modify your application or approve or propose some criteria, some conditions that might allow us to approve it? And if the applicant says, yes, we'd like that opportunity, but it's going to take us a couple of weeks, we have to go back and meet with our planners, our engineers, our designers. In that circumstance, those 2 weeks are not subject to the 120-day rule. The city can decide at that point how long to extend the 120-day rule to give the applicant time to modify the application or propose conditions. And that's the only time that I'm aware of that the city actually can control the 120-day rule. Otherwise, it's entirely within the applicant's control. Another thing that's important to keep in mind, that you have to keep in mind, is there's a statute, another statute, ORS 197.763, and all of these quasi-judicial hearings, if you've been in this business for any amount of time, we refer to them as 763 hearings, because that statute begins by saying the following procedures apply to all quasi-judicial land use hearings. Planning Commission, City Council, hearings officer, it doesn't matter. If it's a quasi-judicial land use hearing, the statute applies. It says, one of the first things it says is an issue has to be raised in the local proceedings in order to provide the basis for an appeal to LUBA. It's called the raise it or waive it rule. I call it the no ambush rule. Some cities have in their code, I don't know if Sandy does, I'll have to go back and look, but some cities also apply that rule locally to say if you didn't raise an issue before the Planning Commission, you can't raise it for the first time to the City Council. The no ambush rule, you got to get your issues out there and be fair, give people a chance to respond. The statute then goes on to describe how much notice you have to give of quasi-judicial hearings, who gets notice, 100 feet if it's within a city, 200, I think it's 250 feet if it's outside the city but inside the UGB, 500 feet if it's outside the UGB. Those folks within those boundaries are required to get notice. You have to have a staff report. Staff report has to be available 7 days before the hearing. People are entitled to get a copy of the staff report. The staff report has to list all of the approval criteria so that people know what rules the city is applying. So it's a very detailed statute that lays out in very, again, detailed descriptions of how you have to run your hearing. It says, it's not a rule that applies tonight, but it says that if at the initial land use hearing, which in most cases before the Planning Commission, If someone asks to leave the record open, you have to hold the record open and allow them to put more evidence in the record. And there are specific rules for how long you have to hold it open and who gets to say what when. But that only applies at the initial evidentiary hearing. If somebody comes to you tonight and says, I want you to leave the record open, you don't have to. You can, but you don't have to. And they'll often tell you that the statute requires it. It does not. Okay, so and at the end of the day, you have to reach that final land use decision. It has to be set forth in a written decision that lists the criteria, the evidence that relied on to conclude that the criteria are met or not met. Those are the findings. And findings, as I mentioned earlier, have to be more than conclusory. They can't simply say, here's what here's what our code provision requires. The application shows the evidence in the record shows the criteria is met. That's just a conclusory finding. You have to explain why something is met. And that's really more an issue for staff and making sure that the findings they present to you are adequate. But at the end of the day, it's your decision. It's the council's decision. You have to make sure that you've read the staff report and the findings and that you agree with them. Another thing that is important to keep in mind is something called deference. If it comes down to what does a code provision mean, right? There are two or more interpretations of a code provision. The courts and the Land Use Board of Appeals will defer to a city council's interpretation of its own ordinance. So if there's a question about what a code provision requires, try to be specific about how you interpret that. And then staff can get it in the decision and the courts will defer to that and LUBA will defer to that. And the theory is that nobody is better positioned to understand what a provision means than the group that adopted it. If a code provision was adopted by the city council, presumably the city council knows what it intended. And unless your interpretation is so at odds with the text of the provision that it's implausible, the courts will defer to it. And that the ultimate actually is the test. If your interpretation is plausible, the courts will defer to it. But it has to be a decision by the city council. The courts and LUBA will not defer to a decision of the planning commission because they don't adopt the code, or a hearings officer, same thing. It's got to be a city council decision. There is something I did want to touch base on in the public records or public meetings context. I don't know if this has come up in your trainings with LOC and others, but this notion of what is known colloquially as a walking quorum. I refer to it as the never hit reply all rule. And that is, if something is pending before you and a quorum of the city council starts discussing it, that's a public meeting and the public is entitled to attend, to observe. You have to provide notice. All of the things that apply to a public meeting apply. But what if 3 or more of you or 4 more of you are on an email chain? We don't have a quorum in the same room at the same time, so arguably it's not a quorum. I don't think that, I wish Chad were here, he could tell you, I'm not aware of any court cases on that, directly on that point in Oregon, but there have been some in Washington, and the courts in Oregon have come very close to saying it doesn't matter if you're in the same room at the same time. If you are in real time or something very close to real time, there's a quorum of you deliberating on a matter that's pending before you. That's a public meeting. And if you didn't give didn't give proper notice and opportunity to attend, then it's a public meetings violation. Yes, Councilor Exner.
Yeah, in the days before when we had actual face-to-face meetings, it's been so long now, I'm trying to figure out how that was, if it ever will be. We used to go to seminars, League of Oregon, a whole council would show up. There'd be 5 or 6 or 7 of us there, and over beer and wine, since I'm a wine guy, we would talk about issues, try not to make decisions, but certainly we got kind of nervous when we ever got close to any kind of position about making decisions. Where would that line be? If say we go to League of Oregon, 6 of us go, and we're going to talk about stuff. Right. In the evenings. Where did that line cross?
Yeah, so I'll give you the example that this came up in one of the more recent cases. And the bottom line is you're okay in that scenario. The case that got folks in trouble was the Lane County Board of Commissioners. And there was a budget adjustment on the agenda. And one of the commissioners, and they all had offices in the same building, and one of the commissioners went to the second one and said, how are you going to vote on this thing? And they discussed it and they deliberated on it, and he figured out how his colleague was going to vote. And then he went to the third one and they had a similar discussion. And so by the time they walked into the hearing room, they already knew what how the vote was going to go, right? They had figured it out outside of public view. And the court said I don't care if you never had a quorum in the same room at the same time. That's what they call it. You're just walking from room to room and having a contemporaneous discussion. That's a public meeting, even if you're not all in the same room at the same time. But in the course of reaching that, they did contrast that to what you're talking about. And the example they gave was this there was a school board in Lane County, so I think it was Springfield. And they would go out after every board meeting to the local diner and sit around and talk shop, right? Almost the entire school board. Isn't that a public meetings law violation? You've got a quorum of the board discussing school board business. And the court said, no, you're not, because you're not deliberating. And that's really the word it comes down to. If you're deliberating on a matter that's pending before you, then it's a public meeting and the public is entitled to attend and hear what you're thinking, you're saying. But sitting around and talking shop, you're not deliberating on anything. And the court said, you're probably just listening to each other and finding out who's hearing what from whom and what people's thoughts are. You're ultimately just information gathering, and you'll use that information later, or maybe not, in making your decisions. But if you're just sitting around talking shop, it's not a problem. Going to birthday parties, having beer or wine after a meeting, not a problem, as long as you're not deliberating on something that's pending before you.
Would that be ex parte then? I mean, we're discussing wastewater treatment plant over beer someplace,
right?
And 5 of us think that's, here we heard about this, we heard about that.
No. So ex parte only applies in a quasi-judicial context, and it only applies once the application is filed. Because before an application is filed, it's not pending before you. It's not pending before the city. So if you know that your wastewater treatment plant is obsolete, it's over capacity, it's going to have to be replaced, you can have all the discussions you want about that until the application is filed to site a new treatment plant. And at that point, you have to stop, because at that point it's pending, and any conversations you have would be ex parte. Yes, Councilor Walker.
So I was going to mention tonight that, as far as the views, it was like 2019, early 2020, I forget exact date. I was on the tree committee, and this developer took a few of us out there to look at this site where the views is. Is that, so is what I'm hearing you say is that if there was no development, that's not ex parte? Or
Technically, if the application wasn't filed, then it was not ex parte. On the other hand, you lose absolutely nothing by disclosing everything, right? You can say, I don't think it matters, but, and then tell the story you just told.
Yeah.
It probably doesn't matter, but if it did, you're off the hook, right? So.
And then that, for clarification, several of us, were elected in November. So is anything before that considered, when we weren't an elected official? How does that work?
Yeah, because you were not on the decision-making body at the time you had those communications, it was not a communication with the decision maker. That said, again, the same sort of play it safe rule would apply. I would go ahead and disclose any of those conversations you can remember. Right.
Thank you.
Because now you are making a decision. If your decision is based in part on the information you gathered in those discussions, people are entitled to know.
Very good. Thank you.
Chris?
Yes, Mayor Pulliam.
Yeah, so we've had some different opportunities to go speak with our state representatives, state senators, where there'd be, 4 of us, 5 of us above the quorum number. We'd be advocating for different city projects like, wastewater or whatever it might be. Because we had already collectively kind of deliberated and made a decision as far as the direction of a city that we're going. Do we break any rules by 4 or 5 of us sitting down with a state representative, state senator, and all advocating in the same direction?
No, absolutely not. Again, there's not an application pending before you. You're not determining any single person's rights or the rights of a particular property. You're advocating for a general benefit for the city, which is almost, paradigm legislative sort of decision making. You're pursuing the policies that the city council has set for itself. but you're not acting in a quasi-judicial context, so the ex parte rules do not apply. Oh, and the public meetings laws, no, because they would not apply because there's not a decision pending before you, right? So
Well-
in the example from Lane County, there was a budget adjustment that was on the agenda.
Right, but I guess my question, it gets a little in the weeds, but like our wastewater is a facilities plan that is phased, right? So I think we're in phase 1 of that, for example. But so there's future phases of this of this project. We're going to have decisions in front of us. But
Right.
then again, Chris, we wouldn't be deliberating as a council. It's not like we go into these meetings being like, what are we going to do?
Right.
Usually we have an idea and we're advocating for funding or something for it, right?
Well, what are we going to do is distinctly different from how are we going to vote.
Right. Okay.
If the discussion is how are we going to vote, then it's probably a decision that's pending before you. And if you've got a quorum in the same room at the same time, or even over the phone, you know, and this is where I get back to my never hit reply all rule, because if there's something pending before you and somebody sends out an email that says, I just heard from so-and-so that says the developer is about to pull the plug or whatever, and you hit reply all, you've got a development that's pending before you, and you just, you've got now a contemporaneous communication going on between a quorum of the city council. So just be very, very careful if you ever want to hit reply all. Make sure all you're doing is find out what everyone's lunch order is. The last thing I want to talk about is public records. And I'll just give you I'll jump to the horror story and we can work our way back from there. The city of Beaverton about 15 years ago was pursuing was being fairly aggressive on their annexation policies and practices, and they were annexing roadways. And once they got a property surrounded by city-owned roadways, then they could use the island annexation statute and annex the property. This did not go over well with some property owners who were affected by this, including Nike, and they went after the city. And in the course of the litigation, Nike asked for all public records of certain public officials, including community development directors, city councilors, certain planners, and so on. And the city coughed up a bunch of documents. Nike didn't think it was enough, and ultimately got an order from the court that allowed them to pull the hard drives out of everyone's personal computers because people were doing city work on their personal computers. And so those were turned over to Nike's lawyers, who got to do word searches and do all kinds of digging through people's personal hard drives. If you do city business on your personal devices, then those devices become a repository of public records, and public records are subject to disclosure under the public records laws. So I don't know if you have city issued phones, but it's not a bad idea. And if you do have one, use it. Don't use your personal device, or at least recognize if you do and you start sending emails back and forth, those emails are all public records, and your phone could be subject to search and being searched for public records. Yes, Councilor Exner.
I've been told that if I can find my city conversations to my city Gmail account, for example, and not my personal accounts, that wouldn't apply. Is that true or not?
To be honest with you, I don't really know, because I don't know the IT well enough. I suspect it's true, but if somebody is really coming after the city hard and they don't believe that you have disclosed everything from your home computer that was on your work Gmail account, although it may be that if it's from your work Gmail account that it's on the city servers, in which case they would go there. But I would talk to your IT folks and find out if there's a chance that some of those public documents are only on your phone or your personal device. And if they are, then they could be subject to a court order to disclose the device. If everything's on the city server, then you're probably okay. And I have studiously avoided all of that education for the last 20 years. So don't ask me.
Hey, Chris, this is Kelly. Just to clarify though, if it's a personal device, the only way that somebody can make a council member or a staff member give that information over is through court order, correct?
Yes and no. I mean, if the city gets a public record request for documents or information or communications on a subject that is on your phone, then you're obligated to comply with a public records request. If you don't comply, you may become subject to a court order. And that's what happened in Beaverton.
Yeah, that's what I was asking. Thank you for the
Right.
clarification.
Yep. So, you know, frankly, I do public business on my phone all the time because I have the most boring telephone in the world. And if the court wants to look at it, they're welcome to. I don't care. But not everybody wants the, it infringes, let's be clear. And if you don't want that infringement, be careful about how you use your personal devices and social media. We are at 6:59 and I don't want to run over. So yes, Councilor Sheldon.
Sorry, I wanted to drag this on just a little longer. Hey, real quick back to the questions about development stuff. So do decisions that when you do have at least some discretion or some interpretation, it would be a better way of looking at it, especially for the quasi-judicial ones. Does your decision or your interpretation of that set precedents for future decisions?
Yes and no. So if you interpret a code provision a particular way, you're pretty much obligated to continue doing that. Unless but a city is not required to continue making the same mistake. If you come to the conclusion that you've been interpreting it incorrectly, you can change the interpretation. You just have to explain why you did so in the findings, right? The city in the past has concluded that, I'll give you an example. There's a case, Tirumali City of Portland, and they had a code provision that for their maximum height limits in the zone that measured that building height from base zone elevation. Well, what do you do if a building's on a slope? Where's the base zone elevation, the uphill base or the downhill base? And the city may have interpreted that in a particular way for years and then concluded, you know what, that's not industry standard. We should follow the industry standard and change the interpretation. So as long as you explain why you're changing the interpretation, then you can, but otherwise you should definitely follow your precedents. One last thing I do want to you're going to hear about this tonight and you're going to hear about it a lot in the future. The legislature changed the laws recently and said for residential development, your approval criteria have to be clear and objective. And if they're not, you can't apply them. The exception is you can have a separate track that allows you to apply more discretionary standards, but it's the applicant's option whether they want to follow that track. And a PD is an example of a discretionary approval process. It comes down to you can mix and match your lot sizes and the types of development and so on if you in return for a benefit, maybe more open space or a carousel or whatever. So there's two tracks. There's a clear and objective track and there's a discretionary track. And in a clear and objective process, you cannot apply criteria that are not clear and objective. So if a standard says that the development has to be consistent with the overall development in the neighborhood, anybody can interpret that to mean whatever they want. That's by definition a subjective standard. And you could not apply that. Just because it's in your code doesn't mean you can apply it. The state statute would trump that. So I think tonight it's a discretionary application, but there are going to be a lot coming before you in the future that have to be reviewed under the clear and objective standard. So just be aware of that. I wanted to highlight that. Anything else, Kelly, for tonight?
I think there's some other stuff we would want to talk about at a future date, such as limited land use decisions and stuff like that. But I think that would be too complicated to try to cover in the next 1 minute. So.
Right. So remember, you've got to, if you want to deny an application, you have to point to criteria you think is not met. And yeah, things that are not, what's that?
It might not be a bad idea if you can touch on that for about a minute, limited land use decisions, and that documents such as the comp plan and the TSP and the parks plan have to be
Okay.
It might not be a bad idea to touch on that for a minute.
So the statutes created a subset of land use decisions, quasi-judicial land use decisions, called a limited land use decision. And it basically comes down to what we call land divisions, subdivisions and partitions. And the statute says for a subdivision, like the views, you can't apply provisions in your concept documents, the part of master plan or a comprehensive plan, unless those provisions have been specifically incorporated into your development code. So what it comes down to at the end of the day is you have to apply the provisions in your development code. You can't look to the comp plan for guidance because the limited land use statute says you can't apply the comp plan unless those provisions have been incorporated into your development code. So again, the statute keeps kicking you back to the criteria that are in your development code. There is some ability to include some of those concept standards by reference, but you need to be very clear and very specific, particularly for residential development, because again, the criteria very often have to be clear and objective. And we had a case recently out of Silverton with a transportation system plan, and LUBA concluded that it was not sufficiently incorporated into the development code for the city to require the developer to comply with the transportation system plan. I can guarantee you that was a surprise to the city. So be very, in the context of a limited land use decision, be very, very cautious and make sure you check with Kelly and maybe the city attorney if you want to rely on a concept document, like a master plan, transportation system plan, comp plan, to approve or deny an application. Is that what you're talking about, Kelly?
Perfect. Yeah, I think we will need to have a larger conversation about that in the near future, especially since we're redoing our comp plan. But yeah, that hit upon the main points, I believe. Thank you, Chris.
All right. Well, thank you, Chris.
Thanks, everyone.
Yeah, thank you. With that, I'm going to close our work session, and we will convene our city council meeting at 7:06. So let's take a quick 5-minute break. All right, let's go ahead and call this city council meeting to order. Please join me in the pledge, standing for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Slow on the flag today, Jeff. Slow on the flag.
Did it work? I'm at work today.
Yeah, it ended up popping up just fine after a little lag.
I'm out of my element. I apologize.
It's all good. Will you please call the roll?
Yes, Councilor Pietzold.
Here.
Councilor Smallwood.
Here.
Councilor Sheldon.
Here.
Councilor Walker.
Here.
Councilor Exner.
Here.
Councilor Hokanson.
Here.
Mayor Pulliam.
Here. All right, we'll start off this evening with our normal review of tonight's agenda. I'll first call for any changes to the agenda. We'll then go into public comment. Please do note there will be an opportunity to provide testimony during a public hearing later during this agenda on the views. But at that time, council will welcome your comments on any other topics. We'll then go into a response to the previous public comments from our last meeting. This is kind of a new item to our agenda where our city will have an opportunity to respond to public comments from our previous meeting. We'll go into a presentation on an audit presentation for our fiscal year that ended June 30th, 2020. On our consent agenda tonight, we have our city council meetings from our minutes from our February 1st meeting, as well as a renewal of the Oregon Public Works Emergency Response Cooperative Agreement. Under old business, we have a planning commission appointment to make. Under new business, we'll have that public hearing for the views plan development. We'll then have a report from Jordan Wheeler, our city manager. We'll go into committee and council reports, and then we'll adjourn for this evening. With that, is there any changes to tonight's agenda or proposed changes to tonight's agenda? All right. So with that, this is time for public comment. Again, remember, if you're here for public testimony on the views, that will be later in the agenda. But the council now welcomes your comments on any other topics at this time. The instructions are on our agenda, but if you'd like to participate and you're online, please click the raised hand button and wait to be recognized. If you're participating via telephone, dial *9 to raise your hand and wait to be recognized. Jeff, please let us know if we have any public comment tonight.
Thank you, Mayor. I do see one hand raised and appears to be Linda Malone. You should be able to unmute yourself now. Please state your name and address for the record, and you'll have 3 minutes. I'll let you know when there are approximately 20 seconds remaining. Welcome.
Yes, Linda Malone, 17740 Bluff Road. And this comment generated from driving into Gresham today and seeing our bus. And I was going to see if the council might consider in the future that when the weather gets like this, doesn't happen very often, but the half a dozen times a year where the roads are so icy that it's really dangerous for people to drive. And some people are very uncomfortable driving on the roads. As long as our buses are going, that we do some sort of a waiver of the fares when the roads are this bad. Go back to the fare list on the days when the roads are icy to try and encourage people to drive in a safe public manner as opposed to on the streets where I saw a lot of fender benders on the sides of the road. And I think that the council should consider a policy of waiving the fare during inclement road conditions. Anyway, that's all I've got.
Thank you. We will again open up for public comment. If you're participating online, click the raise hand button and wait to be recognized. Otherwise, if it's by telephone, dial *9 and wait to be recognized.
Okay, Mayor, I'll just give it 1 more minute. And Mayor, I do not see any other raised hands.
Great, thank you, Jeff. Jordan, response to previous public comments.
Thank you, Mayor. This is a new item that I felt and I think the council agreed with, of adding to the agendas on your regular meetings for a chance to staff to address the public comments that we received at the preceding meetings. And we only had that one public comment, I think, at the last meeting, and staff did address that at the end of the meeting, and that was regarding the public safety fee and what the public safety fee is being used for. I think Chief Roberts had provided another update in the staff reports this month about those vacancies that are currently being filled. I think he has 3 contingent offers out to officers right now. So we do still have a couple vacancies in our police department that we're filling, but that public safety fee was established to hire 2 new officers, which have been hired, and the promotion of one of our sergeants into a lieutenant position. Unfortunately, one of the positions that are now vacated was a sergeant position that will now go through a promotion opportunity in the department to refill that. But like I said, we're kind of excited about adding this to the agenda. Really, the idea is that if there's public comment during the council meeting that is a question for staff or for the city council, and the council would like staff to gather more information, we can come back in a couple weeks and provide that answer. If not, provide the answer that night. So for example, with the public comment from Ms. Malone regarding transit, really is a policy question for council, something that we can easily talk with our transit department about doing if there was interest in making our fares, making it fareless for our buses during inclement weather. But we're happy to take direction on that too. So like I said, there wasn't any other public comment on February 1st or direction to answer, but we felt like this was the right time to add something like this to the agenda and fit it in after the public comment period. Thanks.
Thank you, Jordan. Carl.
Yeah, Jordan, occasionally there'll be something that comes up by one of the city council, and do you plan to do the same sort of thing with that? Questions that can't be answered?
Yeah, you mean if come up at city council during council updates portion of the agenda, or?
Give you an example. A number of months ago, I brought up the idea that there is some sidewalk on Sandy Heights between Bluff Road and I think it's Hamilton, that would be very beneficial to find a way to install by the city, and because it's near a children's bus station and all the rest. So that never got responded to that I'm aware of. So with something like that. Not saying we have to tonight, but.
Yeah, I think this part of the agenda, we'll probably want to keep it for responding to public comments. And then I think in the example of, if a city councilor brings something up during, the council and committee reports, that would be the right time to kind of gauge the rest of the council's interest on, yes, let's follow up on this. Let's add this to our work plan. Let's schedule it for a work session or an upcoming city council meeting, and bring back an answer. Say, if it doesn't rise to the occasion of adding it to an actual agenda item, I can always come back as part of my city manager's report and give them an update on that if the council, wants us to pursue it. Thanks.
Thank you. All right. Thank you, Jordan. Appreciate it. So with that, we will go to an audit presentation from Tanya Moffett with Marina and Company on our fiscal year ending June 30th of 2020. Tyler.
Good evening, Mayor and Council. I'd like to take this opportunity to thank you for being here this evening. We have Tanya Moffett, who's the managing partner of Marina & Co., who's been the city's auditor for a number of years now. I don't have an exact total, but I'm sure Tanya might have a good rough estimate on that. It's been quite a while, a really long-standing partnership we've had with them. Normally, she would come out to a city council meeting and provide paper-bound documents of the audit, comprehensive annual financial report and other audit documents. But tonight we'll be doing that electronically. They're linked in the staff report for your reading pleasure. And I'll turn it over now to Tanya for her to deliver her report.
Honorable Mayor and City Council members, and thank you, Mr. Deems. This year was an unprecedented year. So it was the first time that we have ever done our audit 100% remotely due to the COVID-19 pandemic. And I just want to thank the Deputy City Manager and / Finance Director, Mr. Deems, as well as the City Manager, Mr. Willer, for allowing us to do this, because it helped to keep my team safe as well as your city staff safe. We really appreciated everything that they did during that time. It was a little bit of a different situation because normally they'd hand us like files and things like that, and we'd have to scan those and send those back and forth. But we were still able to do all of the same things that we would do during a standard audit. For example, one of the things that we do is called a walkthrough. And so we would do shared screens where we could see what the individuals in the city were working on, so that we could, it was just as if we were standing over their shoulder, so we were able to see what was going on. And I'm here to report on the June 30, 2020 audit reports for the city of Sandy. And I'm happy to report that we had a unmodified or clean opinion, which is the highest level of a financial statement opinion that we can give on a financial statement. We did apply that financial statement opinion is limited to the basic financial statements as well as the supplementary information. We applied limited procedures to the management discussion and analysis, and some of the schedules for the pension liabilities as well as OPEB liabilities. The introductory section and the statistical section have not been audited by us. Therefore, we expressed no opinion. The city did receive a comprehensive annual a certificate of achievement for excellence in financial reporting for the June 30, 2019 financial statements. And we believe that the city will receive that for the June 30, 2020 financial statements as well. This is something that the city goes for. It's an awards program, which is above and beyond what the city has to do for financial reporting. So for example, the statistical section at the very back of the city's financial statements that has 10 years worth of historical information, that's not required for basic financial statements. And so it is something that the city does that's extra information. It's a great place to go look how the city is doing over the past 10 years because it has a lot of historical information. Just be aware that sometimes you're not comparing apples to apples because there are new accounting pronouncements that come about. And so sometimes there's new changes, and that might be why they may look a little bit different, or maybe it's the different terminology or something like that. But if you compare the June 30, 2019 to the June 30, 2020 financial statements, they are comparable. So there's only one new accounting pronouncement, and that is just basically postponing some of the other accounting pronouncements to a future period. We also performed what is called a single audit So anytime that the city receives over $750,000 of federal funding, then we come in and do what's considered a single audit. It's like a compliance audit to see if the city is complying with those federal statutes and the federal rules and regulations around that federal funding. This year, we looked at the Oregon Department of Transportation's formula grants for rural areas, which was $1.4 million. And the total schedule of expenditures of federal awards, so the total amount that the city spent for the fiscal year ending June 30, 2020, was $2.4 million. And we had no findings on the single audit as well. For the city's urban renewal agency, our opinion was also limited to the basic financial statements, and we had an unmodified or a clean opinion, again, that highest level of opinion that we can give on a financial statement. There are some accounting estimates in the financial statements that I'd like to bring to your attention. So some of the numbers in the financial statements are based off of either actuary science or accounting standard amount of time. So a great example is depreciation. We don't know exactly how long a police car is going to last. It may last 10 years, it may last 4 years. We don't exactly know. So there's a standard number of years that we estimate that it's going to be, that the city estimates that it's going to be useful. And then that amount is depreciated over every single year. Another estimate is the compensated absences payable. So currently, everybody's accumulated leave for vacation payable is at their current salary. That's not taking into consideration any potential cost of living increases or any salary increases that may take place in the future when they actually take that leave or take that vacation. So let's say they have a promotion right after in July or August of 2020, and then they took a vacation, it would be at a higher rate. So that's an estimated amount. The largest estimate on the city's financial statements is the net pension liability. As long as the city is making the required contributions for their pension liability, theoretically that will cover that large net pension liability. And the other one is the other post-employment healthcare benefits, or what we call OPEB benefits. That liability is also the same as long as the city is making their required contributions for OPEB benefits, then that will cover that liability. The nice thing about those two numbers is the net pension liability as well as the OPEB liability number. Those numbers are coming from actuaries, so the city is not making those estimates. They're coming from people who that's their job to come up with that estimated amount. We didn't find any transactions entered into by the city that lacked authoritative guidance. There were some uncorrected misstatements which are immaterial to the financial statements. And those are the same ones that the city has decided not to record in prior years as well. There were audit adjustments necessary for proper presentation of the financial statements. In some cases, management may consult with an outside or other accountant. We are not aware of any other outside consultants besides the consultants that the city used to assist with the overall financial guidance and assistance with review of the closing journal entries and review of the financial statements. At the very end of the city's financial statements, as well as the urban renewal financial statements, there is an independent auditor's report required by Oregon state regulations. The Oregon state legislature has some very specific things that they ask municipal auditors to look at, which include things, for example, like Oregon budget law. We look to ensure that the city has posted the notices appropriately, that the public had the opportunity to come and talk at the public budget law meeting or budget meetings. We also look at highway funds to ensure that the gas tax funds are being used appropriately, as well as public purchasing rules. So ORS 279 to ensure that when the city is going out for bid for something, that everybody has an equal opportunity to bid on those items. We didn't have any findings in any of those areas, with the exception of there were 2 funds that had deficit fund balances at the end of June 30, 2020, and that was the telecommunication fund, which has a deficit fund balance of $120,000, as well as the operations center internal service fund had a deficit of about approximately $4,000. We appreciate the opportunity to have been of service and look forward to working with the city in the future. If you have any questions now or in the future, please do not hesitate to contact me. Again, we'd like to thank everybody within the city for being available to help us through an unprecedented year of doing a remote audit. It's been a pleasure to work with all of them.
Thank you, Tanya. Any questions from counselors? Well, seeing none, I think we're gearing up for a long evening. Thank you so much, Tanya, for your presentation. And Tyler, job well done. You know, great job. You know, you hit those marks because of the work that you do, and just we're really proud to have you in the city. Thank you for everything you do, and thank you for your work on this, Tanya, and your presentation tonight.
Thank you. Have a great night.
Thank you, too. Okay, so with that, we will move forward to our consent agenda this evening. If there's no discussion on it, I will entertain a motion.
I'll make a motion that we approve the consent agenda as it is listed.
Second.
I have a motion from Councilor Exner, a second from Councilor Sheldon that we adopt our consent agenda. All those in favor signify by saying aye or give me a thumbs up.
Aye.
Nay or a thumbs down. Motion carries. All right, with that, we'll go into our Planning Commission appointment. Council, I meant to bring this up during our work session when I was going through the meeting this evening. I think with these two items, there may be some little extra discussion. It worked well last time when people were using the raised hand button on the bottom. That way I don't forget about you in queue as we're going back and forth. So if you wouldn't mind during our discussion using the raised hand button, keeping it up until you have a chance to speak and then promptly taking it down. It's our first time of trying this. I may really regret it and change my mind, but let's maybe give it a shot tonight. That way everybody gets some more equal opportunity to speak and I'm not, you know, forgetting you. Yeah, Councilor Walker. Councilor Walker.
Hey, sorry to be such a obtuse,
Yeah.
but I don't have a little raise hand button on my.
Oh, you don't? Okay, it won't work then. At the bottom of the screen, are you on an iPad or something?
No, I'm on a PC.
Oh,
I have share screen, but.
Bottom, you don't see participant, share screen, raise hand?
Okay, I have participants.
So Kathleen, if you click on participant, you can see your name there under panelist. If you look at the bottom of that, it'll say invite, mute me, or raise hand. I think you can.
Okay, got it. Thank you so much, Lori.
In a different spot. Perfect.
This is obviously not your first rodeo.
That's where mine is too. So I got the way you were talking about it. I think our screens are the same.
Oh, okay.
Yeah.
Cool.
Thank you.
Yep. Perfect, guys. Thank you, everybody. All right. So with that, why don't we get into the staff report? Jordan or Jeff? Not sure who's giving it tonight. Or maybe it's Kelly.
Yeah, Kelly was a staff member, part of this interview process, but we had Mayor Pulliam, Council President Pete Sold, and Councilor Walker, as well as Planning Commissioner Crosby, who did the interviews for the appointment. I think there was 3 individuals that were interviewed as part of that process, and the packet includes a recommendation from the interview committee for the appointment. I think this process follows what the council has set up as the interview process, using a couple city councilors plus the chair of the board or the commission, and often staff sits in there for staff assistance and making sure the interview and the meeting goes smoothly. I'm happy to hear any comments from any of the councilors on the interview process and how that process went. We're always happy to make changes if the council want some improvements or different questions or anything like that. But I believe the recommendation from the interview committee is to appoint Jan Lee to the Planning Commission seat. I think it's seat number 4. And with that, we'll open up for discussion. Thank you.
Awesome. Thank you, Jordan. Yep, 3-1 coming out of the committee supporting Jan Lee for the position. Just a couple items I'll kind of raise in it is one item that Councilor Walker brought up kind of going into the meeting that everybody was very receptive to was, to kind of use, and Kathleen, obviously, pipe in if I represent you wrong here, but use kind of a diversity lens. Obviously, our planning commission is all male except for one female member, and kind of a recognition of that, as well as just kind of decorum and how people behave both publicly, privately, as well as just in these meetings, and showing respect to people during public comment, and then how they interact and have discussions with other counselors as well. And so with that, we had 3 really good applicants. Had a pretty lively discussion. You've all seen the staff report and the recommendation that came from it. I know there was also some additional information on our meeting on the video as well that came out. Hopefully people had a chance to view it. With that, I'll be quiet and wait for any questions or discussion from council. And we're open for discussion. Or a motion to adopt the committee recommendation. Councillor Hokanson.
Hey, just briefly, because it's going to be a long night, but what do you look for in a candidate when you're interviewing, and those of you who are on the panel? What makes somebody good, and how well does this process ferret that out?
This is a question for people on the
committee.
On that committee. Yeah, so I'll just go first. For me, as someone on it, planning commission could be kind of a more technical role. Where you have to have an understanding of the city, the different functions of the city, and how it comes together. At least it's nice to have a general awareness of that. So I think that's pretty key. An ability kind of to have the ability to think through some of the issues we just had in our work session, right? Where, there's times in which there's bias, or where you have to put your bias to the side and stick to your local ordinances and codes. And so the ability, just looking for the ability and a personality type and past experiences to be able to do that as well. And then the final thing was just a kind of a general alignment with, where our council body is in terms of how we view some of these planning, these planning decisions and processes that come through. So that's, and then of course there's diversity and all those kind of lenses in which we kind of look through objectives and general goals we're trying to meet when we're finding, placing people into these positions. The other people on the committee with me was Jeremy and Kathleen. So why don't you guys pipe up if you want?
Yeah, I can go. I have to say, a lot what Stan had said there, but just how they answer the questions that are there. I mean, I do a lot of work and everything else, and just how the flow of what they're trying to communicate and the process of that, because that's part of the process of being on the planning commission. I sat on the planning commission for 2 years, and being able to communicate and do that. Also, an understanding of some of the city and some of the roles. They don't have to be, know everything about that. That's not the point of that, but have an open mind and realize that, convey that when they, some things may come in front of them that they may not agree with, or may not like, that type of thing, realizing biases, but following the code, following what has been kind of set forward for them, and bringing that out in the meeting as well, or in the interview process as well. So kind of going along the lines of what is presented there in that interview. So I hope that helps answer your question there.
I'll speak up. I look at a little bit of diversity, because I think that's important in all our committees. And I look at the thing that kind of, I think, honestly failed us this time is that, we've all been in job interviews where, maybe you're doing it over the phone or something, and there's questions, but they're just reading them off to you. And it's really, I kind of mentioned to the other younger males there on the committee joining me that were awesome, that, women of a certain age, meet myself and, other women my age, it is a little difficult when you're, get to a certain time of your life to kind of be articulate and not ramble a little bit, especially if you tend to do that when you were younger. But anyway, the important part of that is just, I think going forward, we must have questions handed out to the prospective candidates ahead of time. So they have a chance to kind of see what the question is, especially if it's a multi-part question, and answer articulately. And the thing in this situation that really kind of challenged me was the fact that this, the recommendation, the person that had the rationale for recommending the person they did was that they answered the question so clearly, concisely, and the other candidate did not. But it wasn't really till the next day that I started kind of thinking about all that and realizing that the person who answered so clearly and concisely had the questions because they were on the interview committee for a month or two before when they filled the last position there on the planning commission. You know, they had the same questions. So they were able to kind of get the questions and, you know, probably put together, you know, some answers and sound really, you know, and they did sound wonderful. The other person though didn't have that opportunity to kind of see the questions ahead. And so yes, that person did not have as clear and concise answers. You know, that person happens to have, you know, years of experience on the planning commission. And so that's, you know, I don't think it's a matter of, you know, a lack of experience there. And then the third kind of thing that the mayor just mentioned is kind of how the, you know, what the council's positions are on things and kind of the direction we're going. And I did kind of bring that up too, was the fact that, you know, I feel like the planning commission in many ways, they're just calling balls and strikes. Does it meet our code or doesn't it? When it comes to handing out a variance, there's usually some criteria, not always, but sometimes there's criteria as to whether or not a variance should be handed out or not. Sometimes that's just a matter of opinion and, you know, and bias and things like that can come in. But there are also instances where planning commission can make decisions based on kind of where they're coming from. And the person, you know, that's being recommended was really kept emphasizing, you know, affordable housing, affordable housing, affordable housing. And, you know, I think that's something that we do need to look at. But my concern is that I feel like the three of us that won our new positions were all fairly focused on kind of a growth model that is a little different than what we've had in the past. It's not necessarily, you know, giving out, changing comp plans before you had a chance to do the comp plan. It's a little bit more circumspect about how we have responsible growth. And I would be concerned that, you know, the person that, you know, basically ran against me, that I got far more, you know, votes to take that person, you know, I got elected because, you know, many of our residents felt really strongly that, you know, they supported a different direction for growth in our town. And for us to turn around and then appoint that person to the planning commission is a real concern to me. It's kind of almost in some ways to me, I just kind of not very respectful of the vote that I got and the vote that, you know, the direction that people were trying to give all of us as a city council as to where to head with planning and growth in this town. So like I said, I do feel really concerned that the rationale for making the decision was a clear, you know, more articulate answers. And yet, you know, the reason for that was because she had the answers to the test beforehand. So, you know, that's a fairness issue for me too. So I feel, you know, my recommendation at this point would be to kind of more look at kind of, you know, opening it up again and recruiting, or, you know, I was concerned that we didn't have much of a group to pick from diversity wise. So anyway, I've said enough, but I may say more later, but that's kind of where I'm at right now.
Thank you. I hope that answers Councillor Hokinson's question. Councillor Exner. Councillor Exner?
Yeah, the picture moved back and forth like
me too.
It's a little bit like playing ping pong. Anyway, a couple things. Diversity in all of us should be more than just gender. I think some of the reasons I've been on the selection committee for planning commission and many other committees too. And so sometimes those diversity things are about where those people come from, what their background is. Maybe we feel like we need more of a certain style of person, team member. There's a lot of reasons for selecting somebody other than, you know, just some of the obvious things that we seem to be politically pushed towards in the last whatever. So anyway, there's that. Personally, I know the candidates fairly well. I happen to know Miss Lee probably better than the others, but I'm very confident that of her personality, she can represent the things that we're looking for in this category. And that if her impression is one way and she needs to make a decision, I believe she could do that. So following our code and our laws, I think, are something well within her purview. And sometimes selection of somebody because they're an opposite in candidacy is not always the reason for being concerned, because I do believe that people vote for candidates for a lot of different reasons. And so I'm not at all concerned about the fact that somebody got far more points, far more votes, I mean, than someone else, and that perception is they prefer those kind of people on some of our committees. I personally think diversity also includes things like disagreeing, coming from different perspectives, gives us a chance to understand what part of the community thinks as well. So, I don't remember how many votes each person got, but I know that there's a fair amount. So a fair amount of our city thought that either one of those candidates had some reasons for being there. So personally, I'm very supportive of Ms. Lee. I'm not sure what we call her at the moment, but that's probably it for me.
Thank you, Councilor Exner, Councilor Smallwood, and then Councilor Sheldon.
First of all, I want some kudos for remembering to do my raise hand button, because that's like a weird thing for me.
Yeah.
So I have two comments. My first comment is based off of diversity. While diversity is important, I hope that what we're looking at as a council is getting the right people, the best candidate, regardless. There have been lots of lawsuits going both directions that cities have lost because they've either cited things on one side and then not allowed certain people to advance or get a position, and that has gone both ways. And I don't want to put us in a position on either end of the spectrum. Obviously, if we've got, I think, you know, the conversation was regarding, you know, whether it's gender or it's you know, race, diversity. Those things are all very important, but I hope we're going for the best candidate. Second of all, questions. The questions in these interviews, is there a reason that we can't get new questions every time? And that we're reusing questions? Because I don't feel like we should be reusing questions. That's always going to give somebody an advantage. So if I apply for a job multiple times and I'm always asked the same questions, eventually I'm going to answer the way that you want me to answer. So we need, I'm going to advocate that we, every time we do a board, that we get new questions.
Great, thank you, Councilor Smallwood. And agree with that last part for sure. Councilor Sheldon.
Before I go into too much, it looked like Jeff had his hand raised, and I thought maybe he wanted to comment to the question.
Thank you.
Thank you, Councilor Sheldon. I just thought I would add, there were a few changes to the questions from the previous round. But if it's the council's direction that you'd like a whole much more change, we'll certainly take that under advisement. But just for the record, there were a few changes.
Thank you. Can I ask, because that is kind of an issue, having watched the whole 2 hours and some change, and given that of my life back, how substantive were those changes? Or can I ask that?
Not that substantive, but they're just not. I mean, they're one or two, not that substantive.
So I do have to say, I kind of feel like, man, I just that is a kind of a deal with me, because like Lori said, you know, part of an interview is going in there and not really knowing in your response to the question. So if you go in there and you kind of know that, even if you kind of know the direction, but especially if you significantly know the direction, you're going to be a lot more confident in your answers, and it's gonna portray itself in the quality of your answer as well. So I really do struggle with that, all of it, as far as that goes. But even more, I just like to, you know, throw a couple notes out there that I took, and some of them that I think that the other that were mentioned during it that I thought were relevant. And one of that is we have the two candidates that kind of seem like they're being considered the most is what I seen. Both of them have really significant roles, have played significant roles within the government of Sandy. And I think while that has a tangible value, I also got to kind of agree with what Kathleen just stated, is that you have 3 brand new counselors on here that won an election, some of them 3-way elections, 2 of them, not mine, but the other 2. And I believe that they were chosen because people are looking for a change. And I kind of feel like we're choosing diversity over what the public, what my perception is of what the public wants. There was a 3rd candidate out there that I felt gave really good qualified answers that didn't have the questions, that I feel is that chance at, for lack of better terms, fresh blood to the Planning Commission. It seems like the issues that we need to deal with, you know, that some of those could possibly be dealt with, whether it be gender or whatever, if those are, some of those tend to be, for lack of better terms, I'm sorry, leadership issues from within that commission, and someone and controlling how it's the dialogue occurs, much like you do, Stan. You do a good job of that. So I think that needs to be controlled a little better. And then so kind of looking at all 3 of them in an equal space, and I think I'm kind of going a little bit different than both of the options that it seemed to be considered. I also do struggle with a little bit of people are looking for change, and we kind of know where we're going with Jan. We kind of know what we got. And I don't believe that she's gonna, we can look at her past decisions and we can kind of get a gauge of where she's going. And I struggle with that, because I do think our Planning Commission plays a vital role to our city's growth and development, and their opinions greatly matter. We've heard it in past presentations to the council at how a Planning Commission voted 7-1 for this to come forward, or 7-0 to come forward to us. And so obviously their opinions do greatly matter. So I personally am leaning towards Darren, to be blunt, if that is an option, because I think that is the most freshest ideas out there. I think that he has a background that can help him exert himself and to move the city forward in the right way.
Thank you. Appreciate that. A couple of things I just wanted to add. One is and I know you watched the entire questions, Councilor Sheldon, but I mean, these questions are not like gotcha questions. I mean, they're very much like, how would you respond if there was a negative comment about you on Facebook, and what's your general feelings on growth? And so I don't really view those as kind of, keep you on your toes, see how people respond. And we got to shake up the questions each time because they're, so difficult to navigate. I mean, we're really looking for some pretty general, broad, to your point, kind of, leadership, personality type traits with those questions. The other is we keep talking about this last election, and this was a 3-1 committee vote, and the person who got the one, took 3rd place in a 3-way election and got a lot less votes than Jan Lee, who got recommended out of this. So, I mean, I don't know if we can just, start comparing, election totals from the last time on this decision. And for a lot of us, what do we saw what we could expect out of Jan Lee. And I think that's why you saw individuals who had worked with her in the past, feel comfortable voting her out with the recommendation. And some of these were talked about, in the deliberation. And that is, the person talking right now, me. I have a lot of differences with Jan Lee. We think differently on a variety of things. We also think very similarly on a lot of issues. And I think Councilor Peetzold kind of mentioned this as well, is that we both found her someone who was very intelligent, very well researched. When talking about, the dynamics of a board and how people interact or stand up for them or their viewpoint or their constituency, there's a variety of different ways and communication styles. I'm obviously more vocal, right? And I like to talk and I like my opinion to be asserted, and that will sometimes wear on some people. Some people like that about me. Some people very much don't like that about me. But when you think about, like, when I think of Councilor Lee, she's not very much like me in that. She's not a very overbearing person. She isn't somebody that is, gonna fight you on every point. But everybody who's worked with her, I think, can attest is when Jan Lee speaks, everybody else shuts up and listens. And it's because she's well researched, she's thoughtful, she thinks through the issues holistically. She listens to other people's opinions and takes those in before she speaks. And I think that's something that's really important to recognize, especially about her and her leadership ability, is that she definitely is one that, picks and chooses her spots. But when she does so, she's very effective in doing it. So those are just kind of my thoughts on this process. Now, I was looking at my screen when I was talking, so I look up and I see 3 hands up. I don't know the order. I'm going to kind of go with the order in which people have not spoken. So Councilor Hokanson, I think it's been a while since I've heard from you.
Hey, thanks, Mayor. Mine's pretty easy. I just want a procedural question here. Are options to approve Jan, not approve Jan, send it back to get more people? What are our options?
Yeah, I would view it as that, right? I think one is we don't have to take the committee's recommendation. So those were all 3 applicants. Now, I think we rely heavily on the committee's recommendation. I sure would hope that we do. But I think, and tell me if we're wrong, Chris, I saw you pop on the screen there for a second, but if a counselor wants to make a motion to adopt any 3 of the candidates, I believe we're well within our right to second and adopt. And I think we're also can take motions to return to the process and open up the application process, or to take the committee's recommendation. I guess I view 3 options there. So, did I speak out of line, Chris?
No, that's exactly right.
All right, great. Thank you. Appreciate it. So with that, we will go to Councilor Walker, and then Councilor Sheldon.
I guess first I would ask, is Councilor Hokanson finished?
Yeah, I saw it. Yeah.
Okay. Yeah, I just do want, I did kind of pull up the election results, and Linda Malone got 1,800 votes and Jan Lee got 1,500 votes. They both came in second. So there's that, just clarification for the record, please. And then again, one of the concerns that I had with, and I kind of agree with what Rich has said, is that, and kind of also liked what Lori said about, diversity, is I do want to get the best person in there. In this situation, the 2 people had far more experience. Ms. Malone had, years of experience on the Planning Commission, so she's quite capable of doing that. And she also, when she speaks, she knows what she's talking about, and people listen. And I think that's important to recognize. The thing that really kind of sealed it for me, though, with my vote, was the fact that one of the last votes taken before I was placed on the City Council was the Bull Run Terrace vote. And the fact that half the folks on the City Council did reverse their decision and change it. And Jan, voted, and let me just preface this with, she's a great person. She's an awesome lady, and she's sharp and smart and definitely entitled to her, opinion about all this stuff. I just have a different opinion about some of that stuff. And she made the decision to, approve the Bull Run Terrace, which was, something that a lot of, I think, the residents were happy that didn't get approved. So I think it is something that we have to kind of look at. What is the residents, what message were they giving us with the votes that they, with the folks they elected? And I feel like we need to kind of respect that a little bit. And I do have concerns about the positions that she has taken in the past being indicative of what how she would vote in the future. And I guess we always have an option, and I defer to the legal staff here. I suppose we always have an option. If we don't like the decision that the Planning Commission made, we can appeal it to ourselves as a council. I would hate to have to kind of do that, because it doesn't really engender a lot of, trust and respect to the Planning Commission. Can you give us some direction on that?
It'll depend on what your code says. Some codes have a provision that allows a city council to call up a decision of a planning commission on their own, even absent and somebody else actually appealing it. So I'll have to defer to Kelly whether there's a similar provision in the Sandy development code. Sandy, is there something that allows the city council to call up a planning commission decision?
I'll have to say I don't know, because in my 16 years of land use planning, I've never seen that occur in any of the 3 cities I've worked in.
I know there was one decision made at some point in the 30 years I've been here where they took it back.
Suffice it to say, it's pretty rare, but we can check the code and get back to you.
Yeah, I mean, typically it almost happened once in another city I worked in, but they determined that the city council determined they didn't want to do it because they didn't feel like, not only did it not look very good, they felt, but that the planning commission, there was literally like 4 or 5 members that once they caught wind of that said that they were leaving if they did that. So they decided against it. But yeah, I would have to defer to Chris on that.
Yeah, and as I say, I just don't know, but we'll check and get back to you.
Well, I would make a motion that we open it back up and get some additional candidates to apply, given that the one person had the questions and was able to answer more articulately. That'd be my motion.
Thank you, Councilor. Councilor Sheldon.
Yeah, I'm sorry to hog this. So I kind of felt like after my comments, maybe you misperceived them, sir. And so I just want to make it perfectly clear that I know nothing of Jan other than watching her on some councils prior to this. And I have nothing but respect for her public service that she's given this state, the county, and the city over a 10-year, almost, if I remember, as long as some of us have, since I was in grade school. So a long time. And that should be respected, and I greatly do. So I want to make sure I'm not trying to take away from that. I'm just saying that also comes at a cost for us with, and it allows simply a better vetting process to how somebody's going to think. And so that's my thought process there. The last thing is that one thing I heard did mention, I thought I wanted to throw it out to the group, is, it was mentioned in there that the Planning Commission isn't the final say on this, and that we as the council hold that. I also want to point out, though, that comes at a cost to our citizens, to the tune, if I remember right, about $700. Is that right, Kelly? $750?
I'm sorry, what do you, $700?
What's the cost for the citizens to appeal to the city council?
Oh, okay. Sorry, I misunderstood what you're asking.
Mm-hmm.
Yeah, it's like $700 and some.
I believe it was $750 to appeal Bailey Meadows, but I may be a little bit off on that. So I do caution us that the planning commissioner spot is super important, because if a singular person has to come up with $750 to get our opinion, that person's weight has a lot of financial impact on our citizens. And so I do think it's super important that we get somebody in there that's going to make the decisions that we would want to support. So.
Thank you, Counselor. And please know I wasn't like directly responding to anything you said. And if I got a little extra, it was, I'm a big Jan Lee fan. I think very highly of her. Counselor Smallwood, Exner, and then Peetzold.
Actually, Mayor, both Councilor Peetzel and Exner were
Did
ahead.
they? Oh, I'm sorry. Here, we
Yep.
around. Yeah, Counselor Exner. You're muted.
All right, I'll go. A couple things. I remember looking at some of these positions for Planning Commission several years ago. I won't go to how long ago. And they were pretty difficult decisions because the people that were applying were just not qualified whatsoever. And I remember really struggling with trying to figure out, we only had one person apply and that person was not the best in the world whatsoever. To today, where we have 3 candidates that have quite a bit of different backgrounds, and history, but also well qualified. So I'm really impressed by where we have here. Secondly, why should the fact that a person was second place or third place in the amount of votes they got in a previous council election have that kind of impact on whether or not we select that person? For example, so they got 1,200 for, I don't know what Councilor Walker got, but let's say it's significantly more than what Ms. Lee got. There is a segment of the population of Sandy that really thought that Ms. Lee represented their background, their thoughts and their ideals. And so they voted for, quite a few of those folks voted for Ms. Lee. So to discount her completely because she got second place or significantly less or lost, I think I struggle with that kind of decision. I see it in the national elections that are going on here. We have millions and millions of people voting for the person that lost, and we completely discount that group of people because, and the thoughts that they wanted to make, and selected a person that lost, but still we discount them completely. That doesn't seem right for me. So, and then I guess thirdly is, I guess there is a motion on the table and we should respond to that somehow.
We only need to respond if somebody wants to second. I just have not heard a second.
And I am not ready to second that one.
So let's continue on. Council President Pietzel.
Yeah, I just want to kind of point out, look at the situation we're in. We had 3 really good candidates. Really. I mean, you guys saw it too. I mean, I've done these other interviews for a volunteer position, and it's amazing because we've had other times, like Carl had pointed out, that hadn't. And you know, it's any one of these people in a different group of people would have stood heads and shoulders maybe above the rest of the group. You know, it just depends. But all 3 of them were in the same pool, right? And that's how I look at it as well. You know, I know 2 of them personally because I served on the council with both of them. And they have a lot of background. Whether, you know, someone had served more recently than the other, they have a lot of background in our city as well. And they should know a lot about our city as well. But all 3 of them were really good candidates, in my opinion. And so it makes that a hard decision, right, in going forward on that. And so those are the things to think about in the process as well. And so, you know, and I fear that this type of thing we're going through right now, in a way, can really hinder other people volunteering to do something that I've been on the Planning Commission. I know Carl has too. It's a lot of stinking work. It's not an easy task. I mean, there's a lot of hours, in some ways, a lot more than City Council. And so I just want to keep that in mind. People are volunteering to do that too. And so just be cognizant of that. I know both Jan Lee and Linda Malone and respect them highly. And I think they know that, and serve with them, they both do very well. I don't know Darren Wagner, but I got to meet him that day and he did very well and a great asset to our community here in Sandy, and glad he is in Sandy and glad he has opinions in Sandy. And that, you know, and we'll continue to reach out in one way or another. It's great. Our community is growing and it's great to have that. So I just want to point that out because I feel like, you know, in some ways, you know, we're dragging through people who are requesting to put a lot of time into our city on a few of these things. Now, we do have to come to a decision. That decision may be to go back out, which I think would be kind of unfortunate and maybe unfair for the 3 candidates that applied, because I believe that they are all 3 very qualified, and some have had a lot of experience, and that's what some of us have, is more experience than others for sure, and would know land use planning because of the backgrounds that we volunteered for before more, or maybe for interests that we may have. But that's part of the gig in what you come when you go through that interview process. So anyways, those are just my thoughts. I just wanted to kind of put that out there because I just want to make sure I show respect to all 3 candidates, that they were great candidates. And thank you for applying.
Thank you. You're here. Councilor Smallwood.
Okay, now I feel good about talking because everybody else has gone before me. So a couple things. The 3rd candidate is actually Jeremy is my neighbor. He'd be a great asset on planning, I believe. So I do actually know him. But with that said, kind of going back to some comments that have been made, just because I apply for job A and somebody beats me out doesn't mean I'm not qualified for job B down the road. I don't see where winning an election to be a city councilor has anything to do with sitting on a board or a commission for the city of Sandy. What it tells me is that we have people who really want to participate in our city government. And I think that those types of things need to be recognized, because like Councilor Pietzold said, we're all volunteering. We're all volunteering, and this all takes up a lot of people's time. And so I don't think you can discount people because they have some tenacity to continue to want to be involved. And so with that, realizing that there's a motion but no second, I'd like to make a motion that we go with the decision of the Planning Commission, because that's what we asked these people to do, was sit and listen to these interviews and come back to us with a recommendation. So that's my motion, Mayor.
Thank you. We have, Councilor Exner.
I would second that last motion from Councilor Smallwood.
We have a motion by Councilor Smallwood, a second by Councilor Exner. All those in favor signify by saying aye or give me a thumbs up.
Can I just interject really quick? The motion was actually to go with the Planning Commission recommendation. It's the Planning Commission interview panel's recommendation. I just want to clarify that for the record.
I'm sorry, Kelly. Thank you for clarifying.
Oh, not a big deal. I just want to clarify for the record.
Nope, that's good. Thank you.
And I have, like I said, an additional comment, and that is that
we're not open for discussion at this point. We're in the middle of the process. It's point of order. I apologize. All those in favor again signify by saying aye. Aye. Opposed, nay, or a thumbs down. Looks like motion carries 4-3. Was there additional comments?
Yeah, I'm going to, I guess I'm not really feeling like this was a fair process when this person had the answers. And I think that there will be some pushback from some of the members of the public. And I'm not necessarily going to, I'm going to be respectful, but I'm also going to let the public know what the decision was, because it is kind of a insult to me and the folks that voted the position that about growth in this town to appoint somebody that they did, who they disagreed with on the growth issues. So that's going to come back, I think, in the future for us, that it's not going to be well received by a lot of the folks that voted for the 3 of us. And I feel like, it feels like there's kind of a us and them thing here going on in this council. And I understand some of that, but I also understand that, there is going to be some changes and there is going to be some challenges to things. And I don't expect to win every vote. I didn't win this one. Don't expect to. Don't have any concerns about winning every vote, but I am going to be letting the public know what our votes are. So just be prepared for that. I appreciate that. Thanks.
Thank you, Councilor Hokanson.
Thank you, Mayor. I would like to just remind us all that we are a council, and even though I find myself in the minority, my opinion is to support the majority, and I would encourage Councilor Walker and all of us to do so accordingly. That said, I think we can look to maybe improve the process down the road. It felt like we had maybe good consensus for that. And so I would encourage that. Thank you, Mayor.
Absolutely. Thank you. Councilor Exner.
Yeah, Councilor Hokanson replied for me. He did exactly what I want to say.
Great. Thank you. All right, let's move forward in the agenda. Next up is an easy one. So it's public hearings, the views. Let me call this public hearing to order. Well, first I'm going to read instructions for the public hearing testimony. So public testimony for this hearing will be called for in 3 groups: testimony in favor of the proposal, testimony opposed to the proposal, and neutral testimony. If you're participating online, please click the raised hand button at the appropriate time and then wait to be recognized. If you are participating via telephone, dial *9 to raise your hand at the appropriate time and wait to be recognized. Speaker time limits will be up to 20 minutes for the applicant's presentation, up to 3 minutes for each audience member testifying in favor, against, or neutral, and then up to 10 minutes for the applicant's rebuttal. I'm now calling this public hearing for state land use file number 20-028 Subtree Fish PD, and it's 8:11 p.m. I will call for any abstentions from the hearing body. Okay, just for the record, I cannot see Councilor Walker. So Councilor, if you raise your hand or anything in the abstentions, I have no record of it. I will now call for any conflicts of interest from the hearing body. Seeing none, I will poll the hearing body for any ex parte contact. Please include any site visits. Okay.
I did visit the site.
You did visit a site. Okay, great. Thank you. As far as ex parte, every time a community member tried to bring up the topic to me, I would bring up that we're on a public hearing and that I can't talk about it. And I was very strong in that. Councilor Walker.
I visited the site. Is that what the question was?
Yeah, that's where we're at, is we're polling the body for ex parte contact, including site visits.
Yeah. So are you wanting both those or just site visits?
Both. The site visit would be considered an ex parte contact.
Actually, that's up to the lawyer, but let me just, the developers showed a couple of members of the tree committee, and again, I wasn't on the city council at the time, the site in late 2019 or 2020. And mentioned general intentions to develop it and how tree ordinances might apply. It was not a filing at that time in front of the planning department. So there's that. I heard about it at the Parks Board meeting, again, before I was elected. And I did enter the meeting minutes from the 2 meetings where that was discussed, again, before I was elected, into the records. I talked to a member of the public before the election about planning processes, testifying and asking for continuances. This discussion was about general processes and not about specifics, since I didn't know what they were. She did express concern about an apartment building beyond her backyard. And then I listened to the Planning Commission meetings in November and December and heard the same public person reiterate her concerns about her backyard view. And I had no other contact on Facebook or other sites about the views. So that was the extent of my contact. And like I said, they were all before I was elected. So according to our attorney tonight, that I wasn't a deliberating body or something. I'll let him clarify what that means for me.
Thank you, Councilor.
You were not part of the decision-making body at the time. You are now, but you just disclosed all of your ex-parte communications so they can be addressed by the parties. So we're good.
Councilor Sheldon.
Yeah, I went out. Sorry, let me take my hand down. I went out and I saw I did a site visit to kind of get an idea of what it looks like. And then I also, prior to being elected, heard the planning commission meetings on this.
Thank you, Counselor. All right. All right, now I'm going to call for any challenges to members of the hearing body. To bring a challenge, if you're participating online, click the raise hand button and wait to be recognized. If you're participating via telephone, dial *9 to raise your hand and wait to be recognized. Counselor Exner.
Real quick, I was brought up, I just want to be perfectly clear. I am a realtor and I may receive a commission out of some of these in the future. I have no understanding that I have any possibility, but I might in the future. Just to be perfectly clear.
All right.
And Mayor, I do not see any raised hands for any challenges.
All right. So with that, if you testify, I now need to read the following statements. If you testify, you must raise all issues you wish to address at this hearing. If your issue is not raised at this hearing, you may not be able to raise it later at any appeal. Your comment should state why the application should or should not be approved, or include your proposed modifications you believe are necessary for approval according to the standards. If you do not raise specific issues at the final evidentiary hearing or by the close of the record, or fail to provide statements or evidence to allow the local government or its designee to respond to the issue, you will not be able to appeal the decision to the Land Use Board of Appeals based on that particular issue. Failure of the applicant to raise constitutional or other issues relating to the proposed conditions of approval with enough specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. I will now call for the staff report.
Hi, Mayor and Council. Let me go ahead and share my screen. So tonight we're talking about a plan development, a proposed plan development called the Views. So the site that this is being proposed for is east of Sandy, well, in the eastern portion of Sandy, just north of Highway 26 on either side of Vista Loop Drive. So it's two sites together, total about 32.87 acres. Right now, both sites are zoned SFR, single family residential. That's that light yellow color that you see. And they also have a comprehensive plan designation of low density residential, or LDR. You can see the sites, it's a little confusing, but they're outlined in that green color. You'll also notice a blue triangle. That is important to this application. That designates a Mount Hood viewing area, which is part of the comprehensive plan. So the applicant is requesting.
I apologize, I missed that. What's the Mount Hood viewing area designated?
It's that blue triangle that you see.
Not you. So okay, so that's their proposed viewing center.
So that's actually in the comprehensive plan.
Oh, okay, thank you.
Yeah, yeah. So it's something that has been designated by the comprehensive plan. That is, it also is incorporated in the applicant's proposal. So the applicant's requesting a few things, primarily a plan development. This also includes a zone map amendment, a subdivision, a few special variances, FSH overlay review, and tree removal. And I'll talk about each one of these things. So just a little bit of history. Back in January of 2019, the applicant started a conversation with City of Sandy staff about putting in a residential development on the site. They held the pre-application conference in May of 2019. In June and July of 2020, they submitted all of their application materials, paid their application fees, and city staff deemed the application complete and began the review process of the application. In September of 2020, we met with the Parks and Trails Advisory Board to get their input on the application, particularly on how they're going to be dealing with parks and open space. November 23rd of 2020 was the first Planning Commission hearing. At that hearing, Planning Commission granted a continuance on a resident's request. And the second Planning Commission hearing was held on December 16th, 2020. Finally, tonight, February 16th, is the City Council hearing. So just to give a little bit of background on what a plan development is. So a plan development is both a development type and a legal process. There's a few points of intent. I pulled this from the development code. The intent is to include a mixture of housing types and densities, allowing flexibility in site planning and land use, encouraging environmental conservation, coordinating building form, and providing common recreational areas. So something that's really important to understand with a plan development is that the applicant is allowed to request modifications to quantitative code requirements as part of the plan development process. So things that are quantitative in the development code, such as the size of a lot or the width of a setback, they can request that their plan development deviate from those code requirements. So this is a site plan of the overall proposal. You'll notice that there, if you kind of look over here on the left in the center, you can see the north-south arrow doesn't actually go up and down, so that might be a little bit confusing. But we have the upper views to the north and the lower views to the south. So phase one is the lower views. This includes 39 single-family detached homes, 32 single-family attached homes, which I've outlined there in red. Sometimes we refer to single-family attached homes as townhouses or row houses. And then 15 multifamily homes. Multifamily homes refers to apartment units. Originally, this number was 24 multifamily homes, but the applicant decided to reduce that by 9 to make it a 2-story apartment building to include 15 multifamily units. Phase 2 is the upper views. This includes 49 single-family detached homes and then 24 multifamily homes. So there was just a little bit of confusion with this at the Planning Commission meeting, but the applicant is requesting to subdivide these sites into 122 lots. So 120 of those lots will be single-family homes. Of those 120, 32 are attached single-family, 88 are detached single-family. And then of the 122 total lots, 2 of them are multifamily. One of them has 24 units, one of them has 15 units, and that comes out to a total of 159 total dwelling units. So part of the plan development process requires a zone map amendment. According to the plan development chapter 17.64, when a plan development project has been approved, the official zoning map shall be amended by ordinance to denote the new PD, plan development overlay designation. So something that's really important to understand is that this is not a change to the underlying zoning designation. This is just amending the map to denote this area is a plan development. So a few of the code deviation requests, and these are outlined in detail in the staff report, are including row houses and multifamily housing, which those things are not outright permitted uses in single-family residential zoned districts. But that is a request that they are making. They're also requesting some smaller lot sizes, both to account for the attached single-family homes, as well as some smaller lot sizes for some smaller detached single-family homes. They're requesting smaller minimum average lot width on a few of the lots, smaller interior side yard setbacks on a few lots, smaller rear yard setbacks on a few lots, and longer block lengths for some of the internal streets. And again, the details for all of these are in the staff report. So the applicant is also requesting 2 special variances. So it's important to remember that the plan development allows for deviations on quantitative portions of the development code, whereas any qualitative code deviations require a special variance. So there are two special variances. One is, and I'll go into detail on each of these. One is for the homes in the upper views that abut Highway 26. The code says that they would need to orient their front doors towards Highway 26. And the applicant is requesting that instead of that, that they can orient their doors internally to the internal residential streets. And the second special variance that the applicant is requesting is to remove sidewalks from a few of the street frontages. So I'll go through both of those. First, the front doors. So again, we have a specific code chapter in the development code that talks about homes that face or homes that abut transit streets, and Highway 26 is a transit street. And a number of the lots in the upper views do abut Highway 26. They're the lots that you see outlined in red there, and the applicant is requesting that the homes, instead of orienting towards Highway 26, they orient towards that internal street. The second special variance that is being requested is related to the requirement to put in sidewalks and planter strips along the streets. The applicant is requesting to waive that sidewalk and planter strip requirement along the south side of the view drive. So you can see in that picture where that red is where they are proposing to install what they call meandering walkways with allays of trees in lieu of sidewalks.
Hey, Shelley, can I ask a super quick question?
Absolutely.
Yeah, can you go back one slide?
Yeah.
I'm sorry, I wasn't fast enough on my unmute button. Apologize.
No, you're okay.
Hey, so if the request to change the front door to not face Highway 26, which I totally understand, do these, and maybe you know or don't know, do these have attached garages to them?
That's something I don't know. Either the applicant would need to answer that, or we would need to come back with an answer for that.
That's fair. Thank you.
Okay, you're welcome. So we also did a review of the flood and slope hazard overlay. Part of the, oh, I'm sorry.
I'm sorry to interrupt. The walkway, the Mirandine walkway.
Yeah.
Just will you take us through the difference between an actual sidewalk and what they're describing there?
Yeah, so the applicant will probably do a better job explaining that than I will, but basically what they're proposing is, instead of the requirements for sidewalks and planter strips that we have, that they're wanting to put in, so meandering meaning, you know, not just going in a straight line, with trees on either side of those sidewalks.
That paved?
Yes.
Thank you.
And I guess I'll ask now too, go back, there you go. In contrast to where would they normally be asked to put the sidewalks if they're saying we don't want?
So on the south side of the view drive. So I don't know if you can actually see my cursor here. But the view drive is what connects the upper views and the lower views.
Got it. We can see it, Shelley. Thanks.
Okay, perfect.
Yep.
Perfect. So the code would require a sidewalk along the south side of the view drive.
Okay,
and they're requesting a special variance to not include that sidewalk.
So just to clarify, the code would require sidewalks on both sides of the street,
Yes,
and we're getting rid of one of them,
correct.
or they're asking to.
Mm-hmm.
And also, if you go back to the north, or the, I don't know, the one that borders 26,
Yes.
there would be no sidewalk along 26 as well.
That is actually one of the conditions that staff is recommending, that they do install the sidewalk along Highway 26.
Okay.
Yeah.
Question?
Sure.
Again, since we're on the sidewalks and also, can you go forward that one slide you had? And this is kind of for both of them. So there's no sidewalk on the north side of Vista Loop there by the higher, what is that, the upper views? There's no sidewalk on the upper side. but that's not required because that's not part of the development, as I understand. But as you go down to the lower views, I understand you're not proposing a sidewalk or anything on the Johnson RV property there. But once you get into that neighborhood and you've kind of cut off some of the streets there, are there sidewalks or whatever in the rest of those streets within the lower views?
It's my understanding that yes, there are. The applicant can speak to more detail.
Okay.
But yes.
Thank you.
You're welcome. Did we have any more sidewalk questions? Okay. Okay, so we also reviewed the flood and slope hazard overlay. Part of the site in the lower views does include part of the FSH, or the flood and slope hazard overlay. So we asked for, wetland delineation. We asked for them to map the FSH, and part of the code requirement is that, you can't develop in the FSH, and they are not proposing any development within the FSH. I just wanted to make that a little more clear. So the applicant is proposing phasing. So phase 1 would be the lower views, and phase 2 would be the upper views. One question that the applicant had for us was with the parks fee in lieu. Because the applicant is not dedicating any parkland to the city, they're requesting that they can pay the fee in lieu, which is determined by the city's master fee schedule. This is kind of a technical piece, but I wanted to include this in here. So we could either calculate the fee in lieu for the entire development for both the lower views and the upper views, but since it is in phases, the Planning Commission recommends that the parks fee in lieu are paid prior to each phase being recorded. So they would pay the parks fee in lieu for phase 1 when that phase, the lower views, is recorded, and then they would pay the parks fee in lieu for phase 2, the upper views, when that phase is recorded. And then with the expiration date with phasing, Planning Commission recommends that each phase is allowed 2 years to complete platting requirements, with the 2-year clock starting for the second phase at the recording date of phase 1. Which this is in the development code. So they are making that recommendation based on what's already existing in the development code. So there is quite a bit of open space being proposed. Even though it's not dedicated to the city, it's being proposed as private open space. And the applicant explains that an HOA, a homeowners association, would be responsible for all of that open space and for that meandering sidewalk. Staff did recommend that in the event that the HOA dissolves, the responsibility would be transferred to the adjacent property owners. With that, if maintenance of the area is not sufficiently performed, the city can maintain them and then charge the appropriate party. So that's either charging the HOA or charging the adjacent property owner if the HOA has dissolved.
Shelley, or maybe for someone else, is that common practice, or are we trying to change course and correct course, I guess it's a better word, of what we've previously done?
Yeah,
That's a really good question.
I can try to answer
Yeah.
that. And what I'm going to say is I would refer to our city attorney. HOAs commonly dissolve, and what we're trying to do is not prevent an HOA from dissolving. We have no legislative ability to do that. But what we're trying to do is that in the event that it does dissolve, which is pretty common, that there would be some conditions related to when it does dissolve. So Chris, do you want to speak to that at all?
Right. So the problem, the central problem is that a homeowners association and the CC&Rs, the covenants, conditions, and restrictions that govern the HOA, is a private contract between the private parties, all the homeowners, and what they're all agreeing to between and among themselves. The city is not a party to that agreement and therefore has no ability to control who does what. But people often over time start objecting to paying homeowner HOA assessments, and nobody wants to be the bad guy, and so eventually the HOA just stops functioning. So then who takes care of the open spaces, the entry monuments, all of the other things, the play structures that the HOA is supposed to maintain? And very often nobody does, or a city ends up eventually taking them over, but that can be a long, complicated process because you have to get a certain number of the owners to agree to that and sign on to it. So we are exploring various ways to allow a city, and maybe, frankly, the answer may be to put something in code that to allow the third bullet there. If an area is not maintained, the city can, under its nuisance authority, go in and take care of it and then assess affected property owners for the cost of the maintenance. So we're looking at various options, but it's a difficult problem, to be honest with you.
So if I'm playing basketball on their basketball court and I trip over something and break my leg, who am I suing?
The HOA.
And if the HOA is no longer there?
Becomes a more complicated question. The city, the city would probably have the same kind of immunities that would apply in other circumstances if somebody on a city playground fell and broke their leg.
Exactly. But if I'm a private citizen that now has some sort of liability over that basketball court, you can sue me personally, correct?
Right. Well, you'd probably sue the HOA, not the individual property owners.
But if the HOA is dissolved, who are you going after?
Nobody. Nobody's liable. But if the city formally takes it over and assumes responsibility for the maintenance, then the city would be potentially liable.
Well, you get immunity for that.
There are various forms of immunity. Without knowing the specific facts, it's hard to talk to say in a vacuum whether the city ultimately would be liable.
I'm sorry to go round and round. I just want to be very clear, though. If the HOA dissolves and the responsibility is therefore transferred to adjacent property owners, they're not held liable then as a result for actions on that property?
If the property were to formally transfer to the city, that's correct. I don't know that we have that scenario yet, though. I'll defer to Shelley. I'm not aware of anything in the agreement or in our discussions with the developer that reaches that conclusion, but I haven't been at every meeting either.
Yeah. Okay.
Yeah, I can speak to that. No, we do not. The other thing I'll add to that too is that we're kind of stuck with what it says in the code right now, and what it says in the code is that an HOA is one of their avenues.
Right. And that's not uncommon. I mean, that's a fairly ordinary approach that's taken all over the state, is to save the cities and counties the cost of building and maintaining these things. We've just shifted that responsibility to the private sector, but the private sector doesn't always follow through. And then what happens? Well, we don't have a good answer to that yet.
Okay.
Well, I'll give you, what's happened across the street from me is that the entrance to Whole Sandy Bluff is being maintained by the city park staff. It's not a park. They're out there raking up all the leaves a couple times a year and trimming and all that other stuff. And that kind of concerns me that if there was an HOA there, why aren't they doing that? Why is the city parks department out there? It's not park land. So
yeah, I don't want to get too far off topic, because I think that's a policy discussion that is better suited for a policy venue. And in this case, the question is whether the city's development code allows the formation of an HOA and for the HOA to assume those responsibilities, and it does. And that's what the applicant is proposing.
Yeah, but I would also like to add that I think I would appreciate during the presentation portion for Shelley, if we can kind of stick to more questions, and that some of this is really getting into kind of more of counselor discussion, which should actually come later after you hear from testimony from the public. So just to stay kind of on point and to order, I think the questions should really be limited to the slide show.
Okay. Okay. So the applicant is also proposing a sound wall. Let me just go back a few slides so we can look at that. So the section of the upper views where those homes are right up against Highway 26, that's where the applicant is proposing the sound wall to create a barrier between the highway and those homes. This is a picture provided from the applicant of what it would look like. It's 6 feet tall, made from verticrete. And Planning Commission has made the recommendation to plant additional vegetation between the sound wall and the Highway 26 sidewalk to make it a little more pedestrian friendly. These are a few of the conceptual home designs provided from the applicant. I just want to make sure we're all on the same page that, you know, this isn't a design review application. So we aren't reviewing the design of any of the homes, but we did want to provide some images of some of these proposed homes, you know, a smaller home, a mid-sized home, and a larger home, as well as what the townhomes could potentially look like according to Sandy style architecture. So we wanted to include those to just kind of give a little bit of a visual of what some of these homes would look like. As of the publication of the staff report on February 8th, we had received 32 public comments. All of those public comments are included as exhibits. They're available through the iCompass website. Since we published the staff report, we've received an additional 14 public comments. Again, all of these are available. We made those 14 additional public comments available to City Council. Some of the common concerns that we read through those public comments were potential encroaching development in the FSH, the capacity of services like fire, police, as well as public utilities to handle additional residential development, increased traffic on already busy streets such as Highway 26 and Vista Loop Drive, removal of wild animal habitat by needing to remove a number of trees, a significant increase in housing density over the base SFR zoning density, changing the character of the area, you know, by removing the trees and bringing in a housing development, lowering value of land, lack of potential amenities for future residents, and safety walking long streets, particularly Highway 26 and Vista Loop Drive.
Hey, Shelley, this is Jeff. Just for the record, we added the more recently received public comments to iCompass as well. Just wanted to state that for the record.
Yeah, so all of that is available on the city's website. So what City Council is reviewing tonight is this request for the plan development. Council is required to base their decision on all available information, so staff report, exhibits, the applicant's submission, the presentations made tonight, all public comments, all of these things, that all of the available information is what the foundation of the decision ought to be. Our attorney did draft a list of possible motions. Those are all available at the end of the staff report. I'm sure he would be happy to answer any questions you have about those. And finally, in going through review criteria for plan development, because of the subjective nature of what a plan development is and kind of the trade-offs that you know, City Council is being asked to weigh, the only review criteria in the development code is a little bit vague. It's in 1764-100C, and the review criteria is to ensure consistency with the intent of the plan development chapter, 1764, assure compliance with the general provisions, development standards, and application provisions of the chapter, 1764. And then the third one is not applicable here because it's only applicable to areas that have been designated as a village, which this site does not have a village designation. All right.
So before we,
yeah, let me,
oh yeah, Kelly wanted to say a few things.
Yeah, I wasn't going to say much. I wanted to mainly just ask our attorney, Mr. Crean, to clarify something. I guess there was something said during the training at 6 o'clock that he just wanted to clarify on, and I just wanted to make sure we didn't miss an opportunity to do that at this point.
Yeah, I thinking back on my comments, I think I may have left folks with the impression that this application is a limited land use decision, and so you wouldn't be able to apply otherwise applicable provisions of planning documents like the comp plan or master plan and so on, unless they'd been incorporated into the development code. But if I left that impression, I apologize. This is not a limited land use decision. It's a plan development, which is a discretionary permit. So it's subject to all of the criteria listed in the staff report. I just wanted to clarify that. Thanks.
Great, thank you. Was there any questions for staff before we move to the applicant's presentation? Councillor Hokinson.
Yeah, can you go that? So in their presentation, the last slide where you talked about the intent, I think you also had at one of your first slides, maybe it was slide 7. 7 is the criteria for approving a plan development. Is that correct? I mean, yes, it has to meet all those other things, but it has to achieve the under intent. That's what we're looking for, right?
Right. I believe this is the slide you're talking about, right?
Yes.
Yeah, so kind of. The intent sections in a code are there to help guide you to a decision, but intent sections are not criterion. In fact, intent sections cannot actually be relied upon to make a decision. Those are not actually code standards or code requirements. So they're good things to keep in mind when you're reviewing it, but we actually cannot rely on the intent section to make a determination or recommendation.
Because what wasn't clear to me in the staff report is how these items were met by the proposal. I have to kind of jump to that conclusion.
Yeah, it would be a good policy or a good, it'd be good if the applicant, through their burden of proof, can show that these intents are met. But unless am misinterpreting it, typically intent sections cannot be relied upon as standards or requirements. So, for example, if they didn't meet one of these intents, if you guys found that, I don't think that would be a basis for denial, I guess is what I'm saying.
Yeah, I'm just stuck with the why. Why change? Why approve a plan development? I'm not, there's got to be a motivation, right? And I think the intent gives us the hint as to what that motivation would be.
And I'm going to just kind of jump onto that conversation because your last slide, number 23, Shelley, and I appreciate you making this available for us. Yeah, the very last one there. And I don't, if this is something that we should be waiting till after the presentation, I'm glad to bring it up then. But your criteria, bullet point number 3.1, assure consistency with the intent of this chapter. And so that's where I kind of get confused because the intent part of the code for plan developments talks about plan developments applying to village zones. And this is not a village zone. And I remember there was some kind of discussion at the Planning Commission that, well, we, kind of have done this before. We kind of ignore that or something like that. And so I'm confused by if our review criteria says that we should assure consistency with the intent of the chapter, and the intent section of the chapter clearly states that the intent is that these apply to villages and not to just changing. In another section, it does say that it can apply to all zones. So it's a bit inconsistent in the code language that I think probably should be cleaned up. But for the purposes here, I guess what you said, Kelly, is kind of confusing to me because it's not a village zone, and so it doesn't appear to be consistent with the intent section of the chapter. So can you
Yeah, I agree with you, Councilor Walker. I think it's written poorly, and I'll rely on Mr. Crean, but yeah, it is very explicit in the plan development chapter that it applies to all zones. It is kind of odd that it says it's a village zone thing in the intent section, but my understanding from speaking to our attorney's office is that the section that says it applies to all zones trumps the intent section. Can you clarify that, Chris?
That's correct. If you look at 17.64.100C, it lists 3 review criteria for the conception for a plan development. The first one is assure consistency with the intent of the chapter. And if you look back, it lists 6 or 7 or 8 various intents that the city council obviously hoped that this chapter would achieve. Maybe not all of them with every development, but those are the goals, right? And if you look at 17.64.100C3, it begins with the phrase when located in a village, comma. So clearly the code did not foresee that all of them would be located in a village, but some would be. Hence the phrase when located in a village, comma. So there may have been an intent at the time that many of them would be. That's why there's the reference to villages in the intent section. But you shouldn't read the intent section as criteria. They're goals that the council hoped that this chapter would accomplish, rather than specific criteria that every plan development must meet in order to be approved. Does that make sense?
I mean,
Does our code make sense? Is that the question? I'm not going to answer that.
Councilor Walker, I mean, I do agree with you. It's very confusing. And that is why when we had planned, so I've been working here since 2011. I think I told the Planning Commission this. This is the first plan development that's been proposed since 2011. Now, there were plan developments proposed prior to 2011, but when this one came in at the pre-app, that's why we reached out to our attorney's office to get an interpretation, because there were some confusion between the intent and the other section within that chapter that it says it applies to all zones. So I agree with you. It is very confusing.
All right. Any other questions for staff before we go on to the applicant's presentation? There'll be plenty of time for questions. All right.
Okay, well, I mean, so I can ask questions later because I have a bunch of questions, but I don't want to, I want to hear from the proponent. You might answer them.
Absolutely, Counselor. So I'll look ahead here just in, so basically, you know, there'll be a rebuttal time, and then we can have a discussion between the rebuttal by the applicant and when we close the motion for public hearing. Because once we close the public hearing at that point, then you'll be able to ask questions of staff, but you won't be able to ask any questions of the applicant, right? And so that's kind of your last time to ask questions of the applicant. And then after we close the public hearing, we jump into discussion with each other. So kind of think, okay, good, thumbs up. All right, cool. So with that, let's get into the 20 minutes for the applicant's presentation. Ray, are you going? Is that you?
Actually, this is Mac even. I'm at Ray's office.
Oh, yeah, hey, Mac. I was like, that doesn't look like Ray. Hey, Mac.
I don't know what facial hair that he does.
Yeah. Go ahead. I see Mr. Mike Robinson. Welcome.
Yeah, I just want to introduce myself. I'm Mac even. I'm the developer, and Ray Moore is our engineer and surveyor. Tracy Brown is our land use planner. Mike Art is our traffic engineer, and Mike Robinson is land use attorney. So that's my team. Just a little bit about me. Oh, we can't hear you, Mike.
I know, Mayor, but would you tell us when we get within a couple of minutes of our 20-minute limit, please?
My understanding is Jeff plans on giving you a 2-minute warning. Does that work?
That does. Thank you, sir.
Great, thank you.
I'm planning on keeping my portion of it short and sweet if I can. I do want to address some of the things that came up in the discussion real quick though afterwards. My name is Mac Even. I'm a local builder and developer. I've grown up in this community. I grew up in Boring. I live in East Gresham, kind of between Gresham and Sandy right now. And I've been building and developing here my entire life. My father was also a builder and a developer. So I've been part of this community since I was a child. I love this community out here, and I want to do what I can to promote positive growth. The project that we're proposing is taking a fairly difficult piece of property that has a lot of environmental overlays and steep slopes and some wetland areas, and we're doing our best that we can to preserve all those areas, plus preserve as many trees and natural amenities as we can, and put a big portion of the property into open space, and passive and active open space. We're also proposing parks, and we're proposing more land than is required to be able to do a planned development. With the planned development, we're looking for a mix of housing types that can appeal to a broad spectrum of buyers, renters, people of different household formations, and whatnot. So it's we've really tried our best to be as inclusive as we can to as many different housing needs that the community has. and give as many amenities as we possibly can to make it make it more livable and a better community for the neighborhood and the city as a whole, and also for the residents that are going to be living there. Like I said, I want to keep my part short because Mike's going to take over, but a couple of things that I wanted to clarify. The sidewalk issue on Vista Drive, we're asking to not build the sidewalk on the south side of the road. The reason why we're asking for that is because we want to build a wider planter strip and a meandering sidewalk with much more landscape amenities and focus more of the positive things on that side of the road, because the other side is it's a much tighter area and it makes it more difficult to do anything other than just a straight sidewalk. And somebody asked about attached garages, and yes, the intent is for all the houses to have attached garages. And then to touch on the HOA issue for one moment, this HOA isn't going to be like an HOA that's handled like a lot of homeowner associations in neighborhoods where there's no central management, there's nobody really, it's left to the neighborhood to self-manage everything. It's going to have a homeowners association management company that everybody pays their dues to, and that company manages everything. They also manage the meetings and help the citizens that live here take care of everything that needs to be taken care of. And those rules and covenants, conditions, and restrictions will carry with the property. So anybody who buys in this neighborhood is going to be bound by those when they purchase. And then also anybody in the future resale, they will also be bound by it. And so the dues will be collected by a management company, and the maintenance of everything will be managed by a management company. And I have some personal experience with this because my mother lives in a retirement condominium community in Gresham, and it's managed the same way. And that homeowner association has been in force for 60 years, and it is in full force and taking very good care of the property and doing its job. So with that, I appreciate your time and your consideration. I respectfully ask you to vote to approve the project, and I'm going to turn it over to Mike. Thank you.
Thanks, Mac. Good evening, Mayor Pulliam, members of City Council. My name is Michael Robinson. My last name is spelled R-O-B-I-N-S-O-N. My mailing address is 1211 Southwest 5th Avenue, Suite 1900, Portland 97204. I'm here tonight along with Mac, Ray Moore, Mike Ard, and Tracy Brown to ask that the council approve this application. We agree with the staff report. We thought it was well done. We agree with all of the conditions of approval that are feasible to be achieved. And Mayor, I think you already alluded to this, but if council has questions of us about any aspect of the application, the proposed conditions or new conditions council might want to see, we'd ask you to keep the record open long enough to ask us questions, because as you said, once you close it, you lose that opportunity. So we want to be sure we can answer your questions. That's really why we're here tonight. So first of all, we meet the relevant approval criteria. The reason the council should approve the PD is that it provides a better plan with more amenities than would a traditional subdivision. Now, if this application is denied, we're left with a traditional subdivision. Open space or the meandering walkways, the extra landscaping, you won't have the amenities I'm going to describe. You won't have the variety of housing types. And it's not just a matter of trying to be affordable, it's a matter of trying to provide a variety of housing types and not all the same size lots or dimensions or houses. And that's what MAC is being thoughtful about. So frankly, there is a good reason to use a PD in this case. And MAC has more than met the intent of the PD ordinance and I'll try and explain that in a bit more detail. If the application were to be denied, we're left to come back with a traditional subdivision. It may or may not be influenced by House Bill 2001. It may or may not be influenced by a topic we've discussed before, Mayor, which is the needed housing statutes. But we're really not here to say what it might look like. We're here to say that what you have before you is far better than any other kind of development that you could get. And even though the Planning Commission discussion was a bit disjointed because there were 17 questions they had to answer, I think on balance, when you read the staff report, and I thought Shelley and Kelly did a nice job of laying out the questions and how the Planning Commission answered them. I think on balance, they thought this was a good plan. The only thing they didn't like were the changes to the lot dimensions, and I'll talk about that in a minute. I also want to make a couple of other points, and I'll try and do this systematically. Secondly, the application doesn't increase density. The application originally included density bonus request, but as Shelley said, MAC reduced the apartments by 1 story down to 2 in response to neighborhood concerns, and that in turn reduced the number of dwelling units down to no more than would be allowed if we were developing in the SFR zone. We have more open space than is required by the PD ordinance. The PD ordinance requires 25%. We're proposing 36%. We're not proposing any development in the FHA overlay, and we're not proposing higher buildings. The SFR zoning, its maximum height is 35 feet. That's what the neighbors had to say, members of council, the Planning Commission. We always think neighbors are sincere. We understand that when you've had vacant property near your homes, it's difficult and it's oftentimes very startling to see new development proposed. But this is an area that is in the city's UGB. It's in the city's boundary. It's long been planned for residential development. And so the question isn't whether it's going to develop as residential development. The question is how it's going to be developed. And as I said a moment ago, and as I'll say in a little more detail before our 20 minutes is up, we think this is a better plan than the council would see if it were just a traditional subdivision. And I think as Kelly and Shelley alluded to in their staff report, that's the whole reason you have a PUD ordinance. Now, it does place an extra burden on us. There's no doubt about it. But we've accepted that burden, and we believe that as the application and the evidence in the application shows, we've met that burden. And I'm going to talk about, well, let me stop here and maybe answer 2 questions I heard asked during the staff report. And I'll try and do this so I don't use up all my time. Mayor, I think you asked what would happen if the HOA didn't own one of the common amenities any longer, if it were transferred to the individual property owners. I just want to point out that you might not have anyone to sue, and here's a good reason for that. ORS 105.682 provides for recreational immunity from lawsuits for people that are hurt if, as you know, if the property owner gives people the right to enter the land for recreational purposes. And that's intended to encourage, in the words of the statute, wood gathering and gardening and recreational purposes. So if, I don't think there's, I think there's a lot of opinion about whether HOAs are successful or not. My guess is there's far more successful HOAs around than unsuccessful. I don't think they're dissolved very, very often. And as a matter of fact, we have a condition of approval if this is approved requiring an HOA. So I don't think we could legitimately dissolve it and still be in compliance with the conditions. But the point is, back to your question, Mayor, property owners would not be saddled with liability for people who are injured as long as they provide the notice on the property. You're free to recreate on our property. I also want to talk a moment about the intent section. I generally agree with what Kelly had to say, but because we do have the burden of proof, we want to be straightforward and honest because we think we've met it. We do look at the approval criteria in 1764-100. It says you have to assure consistency with the intent of the chapter. Well, the chapter it's referring to is 1764, and I think that takes us back to the intent statements in 1764-00. Now, I don't think you're required to meet all of the intent statements. I think you can balance those because, for example, as you discussed, we're not in a village, so you wouldn't have to meet the intent statement regarding villages. But I do think normally Kelly's right, intent statements aren't approval criteria, but the exception to that rule is where the code expressly makes you an approval criteria, and that's what has occurred here. But we're not concerned about that. Mayor, sorry, I lost my place. Bear with me. Sorry, we're not concerned by that challenge because we believe we meet the intent approval criteria. So let me conclude our presentation by talking about some of the issues that were raised by those who thought this application shouldn't be approved. One issue, and we know this was concerning to folks, was traffic. But what you have is a record that shows an applicant's traffic study prepared by Mike Ard demonstrating that the intersections will perform as required by state and city standards and that it won't result in unsafe conditions. One of the issues had to do, and I'll probably deal with this twice, with folks walking along the streets. MAC's going to provide a meandering sidewalk in the appropriate locations to get people off the street. And that's why we're not going to have a safety problem with that. You had two agencies that looked at our traffic impact analysis, the Oregon Department of Transportation, and also your traffic engineer. Neither of them criticized the study, both of them agreed with it. And as with all public facilities, all of the comments you have in the record from the public agencies demonstrate that in this case, specific case, street standards are met and generally public service standards are met. Another issue was height and the loss of views, and it's hard not to seem dispassionate or cruel when I say this, but the reality is with development, some people lose views. And a point that we wanted to make sure you understood is if this property were developed as a traditional subdivision in the SFR zone, we have, as of right, a maximum height of 35 feet, no more than we're proposing in this subdivision. MAC did reduce and lose 9 units by eliminating the third story of the apartments. And he did that specifically to address the testimony of one of the neighbors. The third point is density. I've already explained we're no longer asking for a density bonus. We're proposing exactly the number of units that would be allowed if this were an SFR zone, Mayor. Preservation of natural areas. We're not proposing to develop in the fish overlay zone. There's no other natural habitat designation on this property, and the tree removal approval criteria has its own standards. Pedestrian safety, I've already addressed that, but at the risk of being redundant, let me say again, the site plan that Shelley showed you tonight is thoughtful. It tries to do something in a unique and imaginative way to both provide safe and efficient pedestrian systems, but without the typical straight line sidewalks. And Mac should be applauded for doing that. Frankly, this might have been easier had he tried to do a traditional subdivision, but he wanted to do something that he thought over the long term would be better for the residents and would, so to speak, weather better over the years. It's going to look better. And lastly, impact on property values. Whether it's good or bad, I've done hundreds of land use hearings, and you've probably heard just as many. Property value impact is always raised, yet it's always raised without any evidence, and there's simply no evidence of that here. But I tend to think that the council could conclude that with a well-done, developed, maintained subdivision, property values wouldn't decline, they would increase. And that's what we're trying to achieve here, is a property that's well thought out and that is developed well. One other thing I want to go back to before I conclude is the open space amenities. The staff report did a nice job of listing them, but I want to add to them. Open play areas, playgrounds, dog park, basketball court, and as Shelley mentioned, the Mount Hood viewing area. All of those are proposed. Those would not be provided because the city does not want to park in this area. So in addition to providing public amenities that will be maintained by the HOA, that frankly the public will use, and making in lieu fee payments for parks, the city is getting the best of both worlds with this project. And let me go back then, if I could, to the intent. If you look at the intent, Mayor and Council, we meet all of those. We're providing a flexible design, we're providing a variety of housing types, and we're providing different kinds of open space. So this application is about meeting the approval criteria. We understand people are concerned about this, but it's not about how many people oppose this or how sincere or intense their opposition is. It's about whether the council finds that we've satisfied our burden of proof. We think that you can find that. Mac has gone out of his way to do a good subdivision that will be a great entryway to Sandy and provide a long-term and good place for folks to live. So with that, Mayor, that's all I have. Again, there are Mac, myself, Ray, Mike, and Tracy all here to answer your questions. And we hope at the end of tonight's hearing, you'll approve this application. And we thank you for your time.
Thank you, Mr. Robinson and Mac, all the applicants, appreciate it. All right, now it's time for public testimony. Here are the guidelines for those of you who wish to speak. Please try to avoid repetition. If someone else has already expressed the same thoughts, it is sufficient to state that you agree with the statement of a previous speaker, even if that's all you say. If you have documents, maps, or letters that you wish to have considered by the body, they must be formally placed into the record of this proceeding. To do that, either before or after you speak, please email your materials to recorder@ci.sandy.or.us, and staff will make sure your evidence is properly processed. As a reminder, testimony for this public hearing will be called for in 3 groups: testimony in favor of the proposal, testimony opposed to the proposal, and neutral testimony. If you're participating online, click the raised hand button and wait at the appropriate time and wait to be recognized. If you're participating via telephone, dial *9 to raise your hand at the appropriate time and wait to be recognized. At this time, I'll call for testimony in favor of the proposal. Please remember to state your name and mailing address for the record. You'll have up to 3 minutes to speak. Jeff, is there anyone wishing to give in favor of the proposal testimony?
Thank you, Mayor. I do see several hands raised. We'll go ahead and click on the first one. You should be able to unmute yourself now. Please state your name and address for the record, and you'll have 3 minutes. I will let everyone know when there are about 20 seconds remaining. Welcome.
Hi, my name is Cassidy Moore, 1912 Southwest 6th Avenue, Portland, Oregon 97201. So just a bit about me. I'm a college student. I'm graduating in the spring. I'm looking for a nice apartment to live, and these really caught my eye. As I'm sure everyone saw from the presentation, they're pretty. There's lots of good community near you, and I think it's really exciting to see some growth in Sandy, especially with how much effort the developer and the engineer have put into making this a nice place to live, not only for the people in the apartment and in some of the duplexes, but also the community and those living near the area. I think we should really look past just apartments in someone's backyard and see that this is community development. And, you know, the place I grew up in someone's backyard. You know, our little neighborhood was in someone's backyard, but we were able to have friends with new neighbors, friends with old neighbors. It really builds to the community and adds a lot of growth. So I'm all for this.
Thank you. Jeff, anyone else?
Okay, Mayor, I do see another hand. This person is joining us on the phone. You should be able to unmute yourself now, and please state your name and address for the record, and you will have 3 minutes. Welcome. I think if you're on the phone, I believe you dial *6 to unmute yourself.
It worked. Hello.
There we go.
Thank you. Thank you. I'd like to save my time for the next section. I accidentally hit at this point. Thank you.
No problem. Thank you.
Okay, Mayor. So I'll click on the next name, Mayor. This person is signed in under the name Makoto Lane. You should be able to unmute yourself now, and please state your name and address for the record, and you will have 3 minutes. Welcome.
Hi, guys. This is Makoto Lane at address 37828 Rachel Drive. I feel like I'm having a case of deja vu as well, all of you. The same attorney going after loopholes that haven't been closed in our city planning code. And I've brought the PD planning code problem of loopholes up many times in many different scenarios. And it's just frustrating to see that there's a number of loopholes within the PD planning code. And the problem with PDs is that it supersedes our regular planning code. Like, what's the point of having zoning areas if somebody's just going to roll right in and do the PD thing, and basically we can't do anything about it, and if we do, we get sued? Is this going to end up the same way as Bailey Meadows? Are we going to have to pay taxpayer dollars to this developer if we don't want this development going in? Again, it's, you know, this is the third one that Attorney Mike Robinson is working on, right? Because he just appealed the other one across the street, the other proposed development across the street. And so my problem here is not only are the number of variances ridiculous, I mean, there's like 7, how many variances are asked as far as property line setbacks or building setbacks to the property line, where the front door resides, sidewalks, and the list goes on and on and on. And so, you know, even according to the planning director, Kelly O'Neill, it would take 6 months for the PD code to be fixed and closed all of the loopholes within it. And so I suggest that the PD planning code gets taken off the table and shelved, fixed in the meantime, whenever a planning department has time to do it, and then reintroduced. Because I have a feeling this attorney might get $20 million out of the city before the planning codes are fixed. Yeah, there you go. So that's my piece. I don't think we should diverge from the zoning areas, what they're zoned for, the intent of what they're zoned for. I just don't agree with this. Thank you.
Thank you, Makoto. I would like to remind everybody to, this is the time in which people are giving testimony in favor of the application. If you wish to speak in testimony against the proposal, please wait for that time. Jeff, is there anyone else who would like to give testimony in favor of the proposal?
Thank you, Mayor. I do see one more hand up. You should be able to unmute yourself now. And please state your name and address for the record, and you will have 3 minutes. I'll let you know when there are about 20 seconds remaining. Welcome.
Hi, my name is Christina Molina, and my address is 40304 Terrace Street in Sandy. I have lived in this community for 42 years. I live in a subdivision that used to be farmland off of Langen Sands. And I am an agent in town, and I just want to state that I have clients that have grown up in this town that now are having families who want to still live in this community. Last week when I looked, there were 2 homes for sale in Sandy under $500,000. Most of the homes, when they come on the market, it's multiple offers and they're being bid out. And I like this proposed development, number one, because Mac is doing something different. He could just go ahead and do the normal, regular subdivision, but I like that he added more green space. You know, there's a dog park. I have a dog. I love the dog park over there in Sandy Bluff Estate. It's going to give a more affordable housing for people who are just now wanting to think of starting to buy a home, so first-time home buyers. The average sales price is over $400,000 for a first-time home buyer. I just think it's a nice proposal. It's better than just some huge developer coming in and cramming as many homes as they can into that space under your guidelines. He's doing a little bit more, I think, in wanting to provide space and meandering walkways. I would rather have a wandering walkway than just straight and narrow type things. And I love the little view area. So I'm for it.
Thank you, Christine. I appreciate it. Jeff, any more public testimony in favor of the proposal?
Okay, Mayor, I do see another hand up. You should be able to unmute yourself now, and please state your name and address for the record, and you'll have 3 minutes. Welcome.
Good evening. My name is Buzz Ortiz, and I live at 41525 Southeast Vista Loop. And I really think that this is a well-planned development. I've been in this city for some 30-some years, and I've seen some projects come and go, but I think this is one that's been well-planned, and I think it would enhance the neighborhood in reality, because the alternative may be something else that may be too late to change. So I think that this plan could be an asset for the community, and I'm in favor of it. Thank you.
Okay, thank you, sir. Mayor, I'll just take one more look at the list. And I do not see any more raised hands.
Thank you, Jeff. I will now call for testimony against the proposal. Remember to state your name and mailing address for the record, and you'll be provided 3 minutes.
Okay, Mayor, I'll click on the first.
Sorry, just a reminder to use the raised hand button at the appropriate time, and to also dial *9 if you're participating via telephone. Thanks, Jeff.
Thank you, Mayor. I'll click on the first name that I have here on my list. You should be able to unmute yourself now. Please state your name and address for the record, and you'll have 3 minutes. Welcome.
Great, thank you. My name is Greg Becker. I reside at 14585 Bluff Road. I gotta say, I see 3 problems on this development. First is that the developer wants variances to sidestep our development codes. This needs to stop, and the developers need to abide by the codes. Second is the public safety aspect. Each home will have a minimum of 2 vehicles, his and hers. These vehicles will be accessing Highway 26, where traffic is doing 55 to 65 miles an hour. Without a traffic light there, someone is going to be killed. And I hope that the families of the victims are able to access this council meeting video to know that the developer and the council was warned it was going to happen. Third, wetlands. In the developer's own words, there is wetlands there. Has the Oregon Department of Lands been notified? To sum this up, hold to the codes. Make sure ODL has been brought on board, and get a traffic light, and then build to your heart's content, as long as it is done by the codes and safe. Thank you.
Thank you, sir. We continue to look for any public testimony against the proposal. Jeff.
Thank you, Mayor. The next person is joining us via telephone. You should be able to unmute yourself now, and please state your name and address for the record. You'll have 3 minutes. Welcome.
Thank you. My name is John Andrade. I live at 18509 Ortiz Street, which is a street that is connected to Vista Loop Drive. Myself and the neighbors met with Mac, and Mac's a great guy. Mac's doing exactly what he's being advised to do. But most of you know the street, and you know, we have to be notified within 500 feet of a building proposal. Most of us didn't even know about the first apartment building that showed up on Vista Loop till it slid through the planning division and city council. And now Mac would like to put a 3-story apartment building right at the top of Ortiz Street. It's a great development. Shelley, I applaud your presentation, but unfortunately you didn't really show what the small houses look like on top of each other. Maybe 3 in a row would put a better perspective on what the houses truly look like in teeny little lots like that. An HOA sounds great. Sounds very, very Gene Roddenberry of you to want to think that somebody's going to pay an HOA when it's an affordable housing. You think every year or every month they're going to be able to kick in that HOA cost to keep up their infrastructure? You think the neighbors want to deal with people driving off 26 and go, look, there's a basketball court. Let's park off the street, on the street, and have a good old time with the kids. Look, there's a dog park. Isn't that great? Now, I know Mike Robinson said something about nobody wants to see a change. You've had open field and everything there. We don't have a problem with that, the neighbors. But how about something that yields housing that is appealing to the neighbors, not just here, but people who need to expand their families? There's apartments going up everywhere. Why does the apartment building even have to be there? Well, Mac made it perfectly clear in our city meeting, our neighborhood meeting, because he has to cover his infrastructure costs. So if it's about infrastructure costs, I asked the city council, what are we looking to do here? Are we looking to start a new Gresham? So when people come around Shorty's Corner, kaplunk, there's a bunch of apartments, and it looks like we're building a new Gresham here. So welcome to Sandy. And I thought it was very unprofessional, Mike Robinson, how you raised your hand when someone said about you making extra money. That's my closing statement. I've been here 17 years and I've watched the traffic incidents up and down on 26. Put a neighborhood there. And I agree with the other caller from Bluff Road. You're gonna have that on your hands. I like Mac, he's a good guy. He's got a good plan there.
20
But we have to be
seconds.
careful, city. Thank you.
Thank you for your testimony. We're still at the portion for people speaking against the proposal. Use the raised hand button or dial *9 if you're participating via telephone.
Okay, Mayor, I'll click on the next name. You should be able to unmute yourself now. Please state your name and address for the record. You'll have 3 minutes. I'll let you know when there are about 20 seconds remaining. Welcome.
Hi, my name is Lisa Hall, and I live on 18265 Southeast Vista View Court. And I echo John's remarks just now on the HOA dilemma. I also have a question on the Highway 26 sidewalk that the builder is, or the developer is proposing. How far would that sidewalk extend? Would it run out where the property runs out, and then where would that leave the pedestrian? Am I waiting for an answer, or do you want me to just go on?
So please go on. The applicant will have 10 minutes to provide rebuttal.
Okay.
Yeah.
And in Shelley's slides, she mentioned property value, lower value of land. And I just wanted to clarify that the homeowners in the area, there's some expensive homes in the area, and you know, when your mountain view is destroyed by a 2-story apartment building, that's going to impact your property value. And all the neighbors in the area feel that way on some level. And I feel so badly for 2 of the neighbors whose view will just be obliterated. They'll be looking at an apartment building. And then I had a question for Kelly. I previously submitted a letter and most of my letter contained concerns about traffic, a lot on Highway 26. Living here as I have, and my husband for many years, it's frightening to exit and enter Highway 26. And so in the last meeting I mentioned, or in my letter I mentioned, why would we not consider lowering the speed limit on the east side of Sandy, much like it was done on the west side, to 45. And Kelly did send a letter, and I went to look for it today, shortly after the December 16th meeting, and he indicated that
20 seconds.
That a proposal would be made to ODOT to review the speed limit. And I'm just wondering if that's in process, or is that something that residents need to help push forward? And regarding the right-hand turn lane off of Highway 26, I have concerns like all the homeowners in the area do, and I don't feel the traffic analysis was done accurately.
I'm sorry, ma'am, that is 3 minutes. I apologize.
All right, thank you, Jeff. Anyone else for testimony against the proposal?
Mayor, I'd like to quickly ask Mr. Crean, we do have a name of a person who testified in a previous category. My understanding is that you can only testify in one category, but if I'm mistaken, please let me know.
No, the categories are somewhat arbitrary. There's no reason to do that other than it makes somewhat logical sense. But a person's testimony is in the record whether they testified first or last. And allowing them to go twice would give them a benefit that other witnesses don't have.
That's right. That's how I view it as well. Jeff, the only thing I would want to check in with, I see that Mr. Lane's put his hand down, is if you do have somebody else residing at your residence who's a citizen who wishes to provide public testimony, that is something I'd be definitely willing to entertain, just not from the same person.
Correct.
Times. Yep.
And for the record, I manually put the hand down. So perhaps you're correct, Mayor.
So let's definitely check with him just in case.
Okay, understood. Thank you. We will go ahead, and you should be able to unmute yourself now, and please state your name and address for the record, and you'll have 3 minutes.
This is Marco Lane. I just want to make sure that my vote or testimony is counted against and not for. I was in the transition of going from a cell phone to the computer.
Yeah.
So I just want to confirm that.
We got it. We
Correct.
definitely got the message of it, and we'll make sure in the record it shows up opposed. Thank you, Mikado. Appreciate it.
Thank you, sir. Okay. Mayor, I'll go ahead and click on the next name. You should be able to unmute yourself now, and please state your name and address for the record, and you will have 3 minutes. Welcome.
Good evening. My name is Randy Olson. My address is 18515 Ortiz Street. I am the second house from this development, about a good rock throw away. I'll go through a couple quick things. Number one, the list of approved people that approve this, I just want to make it clear on my displeasure on some of that. The first person was 6th Avenue from Portland. I'm not sure, I guess you can get anybody to approve or disapprove of something, but they're in 6th Avenue of Portland, which is a 35-minute drive away. I'm literally 18 feet away from this project. So I wish more people locally would approve it. The next person was Rachel Drive, and that was opposed, and I appreciate him coming back on and saying that. I did think it was a little bit interesting that he mentioned that the lawyer would be getting our tax money, and the lawyer raised his hand. I thought that was pretty, and you can frown or laugh or giggle or whatever, but I think that was unclassy of you to raise your hands, because that's our tax money that you're getting. So kudos for acting like I won't say. The next person listed on there, Buzz Ortiz, good friend of mine, neighbor. I won't mention a lot about it, but Buzz said that this is basically better than what it could be. I don't know if that's good enough. We're the neighbors that have to live through this, and I don't know that that's good enough. I don't think that we have to settle, but again, that is what it is. As far as the traffic issue, and going back to Mr. Hall's comment about the traffic issue at the very beginning, saying that that's been, that fits all the ramification, or all the, I can't remember exactly the word, but I did record it, Mike, just so you do know I did record it. It was something about it met all the criteria. If you think that adding all these houses on that street will not cause major transition changes from a 55 mile an hour to slowing down to making a turn. Oh, by the way, maybe there's 2 cars at the same time doing it. So the second car, how are they going to get slowed down enough when the first car slows down to 10 miles an hour and make that turn? If anybody thinks that that survey is accurate or efficient, you're crazy. I hope that all of you record
20 seconds.
And I hope you all listen to this back when the first child gets killed on that intersection within months of this happening. It's unsafe now. It'll be unsafe worse. So shame on you for some of your giggling in your comments. I'm out. Thank you.
Thank you, sir.
All right.
Mayor, yep.
Additional testimony. Yep.
Okay. And we'll go ahead and click on the next name now. Mayor, you should be able to unmute yourself now. Please state your name and address for the record. You will have 3 minutes. I'll let you know when there are about 20 seconds remaining. Welcome.
Hello, can you hear me?
Yeah.
The screen froze up. Can you hear me?
Yes, go ahead, please.
You see a guy named.
My name's John Barmettler. I live at 41613 Southeast Vista Loop Drive. My wife and I moved here 3 years ago, and we looked into zoning and current development plans for the city and county in and around the property, and nothing really stood out to me at that time, and I didn't even foresee a planned development was the works, and quite frankly, didn't even know what was surprised at what existing zoning codes could be waived if a developer provided features or amenities that were unique and above what a normal tract provides. And I now question exactly what those features are in the use plan development. We've got a map here with a bunch of these amenities, and I'll go right down the list. Half-court basketball areas. Any homeowner can purchase a portable basketball net from Walmart for less than $300. There's nothing special about that, but it sure is going to bring in more traffic. There was some mention of site signage and a welcome to Sandy sign. There's nothing really unique about that. In fact, it would be welcome to the sardine can, since the proposal squeezes so many dwellings so close together, it's ridiculous. The Mount Hood view, I fail to see how this is unique, since almost all of the Highway 26 corridor has a view of Mount Hood. It's also insulting to my neighbor that will have his view obstructed by a necessary apartment building proposed directly in his view of Mount Hood. And a dog park, it's just going to bring more traffic in from other parts of the area. In fact, one lady was proposing that she would come over here from someplace in Portland because it was such a good idea. And the nature area, you're destroying more nature area than would be gained by many tightly fit and unsightly row houses. None of these so-called features or amenities really adds up to building codes to be waived. There's also major concerns about fire, police, emergency services. The front of lower views row houses requires frontage space that is being waived. How's this going to sit with those services? An apartment is being proposed behind my neighbors and my properties in what I thought was the flood and slope hazard zone. It's sure a steep place back there. I believe it's what you guys are calling the water zone or something like that. It adversely affects our views, and I didn't even know it was allowed. This apartment complex was not addressed in the original letters that came to the homeowners, and after calling Shelley Dennison, I was told that lot 72 was not even going to be developed. Since then, it was discovered that it would be a 3-story tall complex, but still no rendering of that was available to even what it would look like. And it's since been proposed to only be 2 stories, 35 feet, yes, is a maximum thing. And that's still going to be in our way. It's just going to be an ugly thing. On a personal note, you have the upper views proposing Knapp Street that would face traffic directly into my living room and bedrooms, making nighttime traffic flood the house with lights. Make our driveway a convenient turnaround spot.
Thank you, sir. That is 3 minutes. Thank you, sir. Okay, Mayor, I do see one more hand. You should be able to unmute yourself now. Please state your name and address for the record, and you will have 3 minutes. Welcome.
Hi, this is Sue Gabriel. I live at 19300 Southeast Long Street Lane. I've been a resident there for 40 years. I'm to the south side of the planned development, not really directly impacted, but I can definitely speak to the traffic concerns. And I know, you said if it's said before, don't say it again, but I don't think we can say that one enough. That one has been something that we've talked about in the planning committee meetings, and it just can't be said enough. That's very difficult to turn onto the highway. I do it all the time where I live. The turning right on that is going to be an extremely dangerous proposition for people coming down the mountain with, barreling cars behind them. I say that, like I said, the most important thing, but I really also want to say that from a pedestrian perspective, people walking along, not just within the Vista Loop area, but assuming those people are going to walk into Sandy, there is no good sidewalk situations from where there will be sidewalk to the city. And if you're going to have a mixture of housing, you're going to have people who are going to be needing to bike or walk to get to the transit. So I think we need to really consider that that's an additional public safety concern. You may recall that we were part of a traffic corridor that I guess recently expired, but there's been many deaths and injury accidents on this section from Shorty's Corner into Sandy. So I don't think we should take that lightly. I feel like my father-in-law used to have property for several years over there. He bought property on Vista View Drive, built a house, lived there for several years. So I'm quite familiar with Vista Loop. The the road itself is in terrible shape. It's been in terrible shape for 30+ years. And the fact that they're fixing part of it, but not all of it, but yet they're bringing an enormous amount of traffic to the fold is also a concern to me. I second all the other things about wildlife corridor. I've had all kinds of bears and deer and cougars and you name it, walking through the woods from that corridor, and I just feel like we're encroaching further on their land. Let's see, I did submit a letter. I'm just going to make sure I've covered all my points here. I can't seem to read it as I'm talking to you.
20 seconds.
Yeah, I wholeheartedly agree that it just doesn't make sense to reduce, to have all these code variances. Why aren't we holding to the codes? I think that's a really strong concern. We did a comprehensive plan for a reason.
Thank you very much.
All right, thank you. Jeff, is there any other testimony against the proposal?
Mayor, I'll just take one more look at the list. And I do not see any other raised hands.
Thank you. I will now call for neutral testimony. These are general comments, neither for nor against the proposal. I remind you that you must state your name and mailing address for the record, and you'll have up to 3 minutes each. Jeff.
Okay, Mayor, I'll just take a quick look. And I do not see any raised hands.
I will now call for staff recap and recommendation.
Great. So I made a few notes, some comments and questions and concerns that I wanted to respond to. So first, I wanted to just kind of reiterate that plan developments are a very common land use tool all over the country. They're a very common tool for growth and development. And the sort of fundamental principle of a plan development is if a developer has a better idea than what the development code allows for, we want to be able to see that, right? So that's the fundamental principle of what a plan development is. And so they're not so much loopholes as they are trade-offs that have to be weighed independently. A second thing that I heard, why are we allowing all of these variances? Variances and adjustments and design deviations are in fact allowed by the development code. So we are sticking to the development code by processing these variances in the way prescribed by the development code. And those variances, these adjustments, these design deviations come before Planning Commission or come before City Council and are considered in these formal public hearings. One thing that I wanted Kelly to address, these concerns about, does there need to be a traffic light at that intersection of Vista Loop Drive and Highway 26 or a right turn lane, or do we need to, lower the speed limit? I really appreciate those comments. And that is something that would need to be petitioned to ODOT. I'll have Kelly speak a little bit more of that because he knows a little bit more about that than I do. Some of the comments about, these small houses on small lots, that's up to buyers if they want to buy a small house on a small lot. And then there was a comment about the traffic analysis, the accuracy of a traffic analysis. It was reviewed. So the traffic analysis was provided to us by the applicant's traffic engineer, which was then reviewed by the city's traffic engineer and by ODOT, who both agreed with the findings of that traffic analysis. The entire application was reviewed by the fire marshal and the public works director to ensure that public service requirements could be met. And then finally, I think there was just a little bit of confusion about this with lot 72. So lot 72, the question was, does it overlay with FSH? And my answer was, no, there's no development in the FSH. And I think there was just a little bit of confusion there. So lot 72 is being proposed to be developed as an apartment complex, but it does not overlay with the flood and slope hazard area. So I want to knock it over to Kelly so he can talk a little bit more about that, petitioning ODOT piece for, a traffic light or a right-hand turn lane or lowering the speed limit.
Yeah, thank you, Shelley. The first thing I want to cover is something that Mike Robinson brought up. He said the intent section is applicable in this case. That's news to me. I'll just be very honest. And if it is, this would be the first application I've ever been involved in my 17 years of land use planning that we can use the intent section as guidance or as regulatory requirements in a process. If that's the case, that gives the city council even more discretion than is typically allowed. I want to refer to Chris Crean, though. That's from working with probably 7 or 8 different land use planners over my career. I've never heard that before. So I'd want Chris to talk to that. And then after he talks to that, then I'll get to the other questions that Shelley brought up.
That's correct. The case law I'm familiar with is pretty consistent, concluding that purpose statements, intent statements are aspirational statements about what the following code provisions are intended to achieve, but are not by themselves approval criteria.
Okay, thank you, Chris. I appreciate that. That was going to be a new one to me. I've never heard of. So I just wanted to clarify that. I don't believe Mr. Robinson is correct. And I just wanted to clarify that I believe he gave incorrect information there. As far as the traffic study is concerned, yeah, I just want to kind of outline that a little bit more. What always happens in every land use application, plan development or not, when there's a traffic study or a traffic letter that's required, the applicant hires a traffic engineer to put that together. That traffic engineer puts it together and then submits it with the land use application. We pay a third-party transportation engineer, since we don't have one on staff, to review that letter. And we rely on that person's expertise to either agree with the transportation analysis that was submitted by the applicant, to disagree, or to point out any flaws. So I have to rely on that individual. If that individual does not find things, I don't have the professional expertise or engineering license to override that person's input. So we rely on that third-party transportation engineer quite heavily. In this case, he agreed with the applicant's transportation analysis that was done by their engineer. And as Shelley pointed out, ODOT did in all regards except to one. The only thing ODOT did not agree with is ODOT said that there had to be additional paving done for a right turn going westbound onto Vista Loop. What then happened is so ODOT submitted that in their comment letter. The applicant's transportation engineer got a hold of that and contacted our transportation engineer, Mr. Replinger, that works for the city. They both actually disagreed with ODOT because ODOT did not supply any evidence or analysis to determine why that was needed. We then reached back out to ODOT, and they have still, to this day, 3 months later, have still not supplied anything additional. So I believe ODOT's recommendation was aspirational. There was nothing to back it up. However, I do want to point out that after hearing the concerns from the public and from our planning commission, I reached out to ODOT the very next day in mid-December and said, okay, irregardless of if we believe as city staff or transportation engineer experts that intersection is satisfactory or not, I want to add that to the TSP scope. So that next day, I think it was like December 17th, that was added to the TSP scope. And so I think it's about an extra $7,000 or $8,000 that the city and ODOT are paying for. I think ODOT's paying the majority of it. And we'll be analyzing that intersection to determine if additional asphalt's needed for a right turn movement to make it safe. So that's going to be analyzed with the TSP. So I wanted to assure the person that made the public comment that will be analyzed. It's just going to be analyzed with the TSP study. The second point is a speed zone investigation. I brought that up to ODOT also on December 17th and tried to add that to the TSP scope of work. They said that, in their however many years of TSPs in the state of Oregon, 35, 40 years, that they've never done that. And even though I pushed pretty hard, I couldn't convince anybody to add it. They relayed back to me that they agree with me that a speed zone investigation east of our downtown out to Shorty's Corner should be done, but that we would have to find a revenue source to make that happen. I think ODOT's probably interested in paying for a portion of it, but I believe the city, probably with transportation, SDCs, or some other form of payment, would need to pony up to help pay for that study. But ODOT was really reluctant to include it as part of the TSP, so I'm 100% confident that will have to be a separate study that's done. I would be happy to hire a consultant to do it. I would just need some funding to get that done. But the speed zone investigation, I don't believe has ever been done east of our downtown. ODOT didn't have any information that it's ever been done. And I do agree with the people that testified both tonight and at the Planning Commission that one needs to be done. Living in town myself, it is a concern, especially when you're, driving westbound and you come into the downtown. It seems like all of a sudden you're out like where the police station is. And I do share the concerns that a lot of the people testifying tonight and at the Planning Commission hearings also said, is that we need to look at that a lot farther. So I just wanted to bring that to council's attention and say that during our budget process, we should probably think about how to accomplish that. So that's all I have to add.
All right, thank you. Is that the conclusion of the staff recap?
Yes.
All right, thank you. So with that, I'm now calling for rebuttal by the applicant. You have 10 minutes.
Thanks, Mayor. Michael Robinson again on the record on behalf of the applicant. Mayor, could you ask Jeff to let me know when I'm at 8 minutes, because I'm going to start, but thank you, but Mac is going to finish. And as we said at the outset, please ask us questions if we have any. It's great that you may have discussion and questions, but if you have them directed to the applicant, please do it while the record is open. So I'm in an awkward position. I never disagree with Kelly or Chris, but I want to just say this in this way. This is really up to the council. I think Kelly is generally right, as is Chris, about intent, but here's the reason I'm even bringing this up. It's not to have a back and forth between planners and lawyers. It's because we have a burden of proof to meet, and people often say, well, applicants are trying to hide things or not meet their burden. I want to make sure that we pointed out to the council what the approval criteria include, and we explained why we met it. So let me just read you what 1764-100C1 says. This is under the heading Review Criteria for Conceptual Development Plan, which is what this is. Request for approval of a conceptual development plan shall be reviewed to 1, assure consistency with the intent of this chapter. And intent is not lowercase, it's capitalized. And if you go up to
Excuse me, I can't hear you, Mr. Robinson.
Thank you.
I've stopped the clock, Mr. Robinson. When you turn your head, I think it's a little bit harder. Yeah.
Thank you, Jeff. How much did you miss? After I said my name?
Maybe. No, I think it was more like maybe the last, 30 seconds.
I've only been doing this for almost a year now, and I'm still not getting the hang of it. My point is, I don't normally disagree with Chris or Kelly. I have the greatest respect for him. But the reason I'm making this point is because we want to be crystal clear about what the approval criteria are, so you can hear why we meet them. And what I had quoted was 1764-100C, which is under the heading Conceptual Development Plan Review Process. And then C is Review Criteria for Conceptual Development Plan. It says, quote, request for approval of a conceptual development plan shall be reviewed to 1, assure consistency with the intent of this chapter. Intent is capitalized, and that refers back to 1764-00 intent. So Kelly and Chris get it right, but the law doesn't just end at intent is not an approval criterion. All of the cases go on to say, unless intent is expressly made an approval criterion. Well, you guys, the council can decide. It seems to me that intent is an approval criterion, and I'm not trying to make this more difficult or, as Kelly said, increase the discretion, but I don't want us to be accused of not having been fulsome in our description of the approval criteria and then address them. That's not what you expect of applicants, and that's why we're raising it. And it looks to me like whether you like it or not, or that's not what I meant to say, whether that should be the way it is, that's what your code says. Intent is a relevant approval standard. So it's for the council ultimately to decide. If you decide it isn't, that's great. It makes it easier for us, less burden. If you decide it is, we've explained why we need the intent, but I'll just explain it in a little more detail. We meet D, promote flexibility in site planning, architectural design, placement, and clustering of structures. F, encourage the conservation of natural features. G, provide usable and suitable recreational facilities and public or common facilities. And H, allow coordination of architectural styles, building forms, and relationship. As I said earlier, I don't think you have to meet all the intent. You balance it. But here, out of the ones, a couple of them simply aren't relevant. We meet the majority of them. Let me then talk about Mr. Lane's testimony. You know, since he raised Bailey Meadows, I want to point something out to the council, and that project is over and done with. But my client made a decision on his own to work with the city on that. And yes, it involved city funds, but it also involved his funds. It involved us going to 17 public hearings, not just at the city, but in front of the county. We had a number of things to do, and we did that because we wanted to be collaborative with the city. I can guarantee you that no one walked away with a pile of cash. And in fact, I talked to my client about a week ago, and he's happy it's over. I think there were some things he might have wanted to have done differently. My point is that nobody is using the process to better themselves. What we're trying to do, Mayor, is follow the code. The PD is part of the code, and use it appropriately as the city intended it to be used when it was enacted. That's all we're trying to do. I don't find any loopholes in the code. It's pretty darn clear, and I think Shelley put it well. It's really a series of trade-offs. If you give us better design and these other standards we want, we'll let you deviate from some of the more rigid standards. That's what it comes down to. And not only does the city of Sandy have this in their code, virtually every city in Oregon that I'm familiar with has it. It's a time-honored and well-used planning tool. I simply don't know what Mr. Lane meant. He was reading something that I didn't read, and he certainly was reading something I didn't say. We're not proposing loopholes. We're proposing to use the code that's in your code. And in terms of variances, there are only 2 requested. And those are both justified and worthy variances. Let's not put a sidewalk on a highway, or on that street. Let's instead do a meandering pathway, and let's not put front doors facing the highway. But 3 other people testified in favor, and all of them made the same point. This is a good project and it provides additional housing. So let me talk generally about some main points. As I just said, the plan development is in your code. It's a tool used by virtually every Oregon city. It's a trade-off, as Shelley said. I can't say it better than she did. We've only asked for 2 variances. The others in the word of the code are deviations from the code. The density and height we're proposing are exactly the same as one would get in the SFR zone. The apartment MAC reduced to 2 stories from 3 and eliminated 9 units to address the neighbors' concerns. We have to develop this property, and it's not that we don't care about the neighbors, but nobody is going to like everything about a project. We're trying to balance what the city wants to see with what would be a good long-term project and responding to the neighbors' concerns. That's why we reduced the height of the building. Shelley and Kelly both had, I think, far better testimony than I can give about traffic, but I'll summarize it. Here's the sentence. We had an applicant's traffic study that was looked at by John Repplinger, your consultant, and ODOT. All of them agreed with it, and there is no competing evidence on that point. That's all there is. And ODOT, for whatever reason, is comfortable with that intersection. Now, I agree with Kelly. If you can get a speed study done and do the other things, that makes sense. But in terms of the box that this application is in, the agencies that review it don't find a problem. The only overlay is the fish zone. There is no other environmental zone. And then just very quickly, Jeff, how much time do I have?
So there are 3.5 minutes remaining.
I'll finish up in a minute or so and then turn over to Mac. We're, and if I get his name wrong, I apologize. Mr. John Andre was concerned about the housing. We're trying to provide a variety of housing. And this is Mac's investment. Mac wants to do the right thing, not only by the city, but by himself. And he is trying to do good design, which encourages a good development over time. And I would point out of the 159 dwelling units, only 39 are multifamily. And that's 9 less than he originally proposed. So same height, same density, less than a quarter of the project is multifamily. I think maybe I've covered everything. So Mayor, Council, I know this is difficult. You should weigh the testimony of your citizens, but that testimony needs to relate to how evidence applies to approval criteria. And here, this applicant is satisfied with substantial evidence, all of the approval criteria. This is not something that we're asking, that we're trying to use loopholes. I don't think such a thing exists in the PD or in the Sandy Development Code generally. And we're not asking for city funds. In fact, we have not objected to not only providing more open space than was required, but we're also, without objection, paying fee in lieu park development. So Mayor, that's all I have to say tonight. As always, we appreciate your time. Please ask us questions and I'll turn over the remaining time to Mac.
And that is 2 minutes.
Yeah.
Sorry, I'm a little bit of a low-tech guy. I want to address a couple of questions that some of the citizens that called in mentioned. Asked how far the sidewalk would extend on Highway 26. It's going to extend the length of the property. We actually had proposed some different alternative sidewalk designs, but ODOT and the city basically said that we needed to do it the way we're doing it. So, and to a point that was brought up a couple times in terms of Mike getting paid by taxpayer dollars, Mike's my attorney. I pay his bill. And so it's not costing the city any money at all. And the wetlands that were brought up, we're protecting all of the open space, all of the wetlands. We are not developing in any of those areas with this application. And as far as the ODOT turn lane, ODOT had a slip lane there that would have been easier to improve to a full turn lane, but several years back, ODOT required it to be removed. The property owner had to pay for that improvement, and it cost him quite a bit of money. And then they came back with no evidence and nothing to back it up, saying, "Hey, we want a turn lane." Why did you have it removed just to have it put back in? It doesn't make any sense to me. Anyway, I wanted to thank everybody for your consideration. I think it's a beautiful project, and I think it's going to add a lot of diversity in housing and different amenities to the community. And I'm really excited to be a part of it, and I hope you feel the same way. Thank you very much. Have a wonderful night.
Mayor, the applicant waives final written argument.
Okay, thank you. All right, so with that, we're open for any questions and discussion before we close the public hearing. This is the opportunity for council. If you have any questions, you'll continue to have opportunities to ask staff questions. Of course, you can do so during this time, but this is also an opportunity to ask the applicant any questions as well. And we're open. Yeah, Councilor Walker, and then I'll go to Councilor Hokanson.
Well, I have a whole bunch of questions here, and I don't want to hog the floor. And so I'm just wondering what I thought I heard you say at the beginning a couple hours ago was that I could ask questions of the staff after all this, but not questions of the developer.
You can at this point, Kathleen. So basically, once we close the public hearing, so the next step would be for a councilor to offer a motion to close the public hearing. Then there'd be a second, then we would vote, right? At that moment, there's no more Q&A with the applicant. What I'm saying is right now we're in a window of time where councilors can't ask the applicant questions if you wish so, because we have not officially closed the public hearing.
I have enough questions that I would almost be making a motion for a continuance with, and you know, if the staff can answer all my questions later, that's fine. I'm a little worried that some of this is, you know, like I think I asked a couple questions and they weren't sure what the answer was. So I think some of these answers are going to require input from the developer as that probably should. So I guess I'm curious whatever, you know, it's 10 o'clock and I'm not sure what everybody else's appetite is for, you know, another hour of question and answer, but continuing it to and leaving the record open so that we have the potential to send the list of questions we have or something like that is probably something to consider. What does everybody else's think?
Yep, let's find out for counselors where we're all at on this and different issues. Counselor Pietzel.
Yeah, I just want to ask, where are we at on the 120-day clock? Because that determines the conversation.
Kelly, do you?
Well, yeah, sorry, I keep turning my video off. I'm trying to leave it to the people that are speaking. Plus, I don't think everybody wants to look at me all the time. I think it's kind of I don't want to say a moot point, but I would hope that the applicant, I see that Mike already has his hand raised, but I would hope that the applicant would be open to extending the clock to a future meeting date so that they can adequately answer questions from not just Councilor Walker, but other councilors as well. So to answer your question, the 120-day clock is March 1st. And that's the date to remind everybody and the new councilors as well that Mayor Pulliam has to sign the order. So it's not actually the hearing date. It's when that order is finalized by staff, which takes at least a week. We prepare it. Mayor Pulliam looks it over and reviews it, tells us if any little modifications need to occur, and then he signs it. So the March 1st date would be very hard to meet if we have a lot of questions. But I would anticipate that the applicant would be open to extending that clock so that they could adequately answer your questions.
Thank you.
I would actually just let Mr. Robinson speak.
Yeah, that's where I was going. I was muted. I apologize. Yeah, Mr. Robinson, why don't you go ahead and reply?
Thank you, Mayor. Thanks, Kelly. Mayor, could we have a 5-minute recess? This is not my decision, it's my client's decision. Could we have a 5-minute recess so I can speak on the phone with my client rather than try and do this text? And Kelly, I didn't hear you. I'm sorry, I couldn't hear the last part. I thought the clock ended the first week in March. What did you say?
March 1st.
March.
Mayor.
3rd or 1st?
First.
Thank you.
Yeah.
Mayor, would you mind giving us a 5-minute recess?
Yep. Let's come back at 10:11.
Thank you.
All right, guys. Mike has his hand back up and he's here. Why don't we go? Yeah, that's great. Let's go, Mr. Robinson.
Thank you, Mayor. Mike Robinson again on behalf of applicant. So the applicant is willing to extend the 120-day period by 14 days from the 1st to the 15th, provided council does two things. One is you would continue the hearing to the next meeting date, which I assume would be 2 weeks from tonight. So maybe we should confirm that first, Mayor.
I believe that's correct.
It would be Monday.
Be a Monday.
Okay. Okay. So what we would do is extend the 120-day period by 14 days. So instead of ending on the 1st, it ends on the 15th. That would give you time to come back at the next meeting on that Monday. And then as Kelly and Chris explained, there's enough time for staff to work with the mayor to get the order issued and the notice mailed. But the second thing is we would continue for the express purpose of coming back to this point in your hearing procedure, Mr. Mayor, where you're asking questions of council, then you move on to questions of the staff and deliberation. We would not be keen on extending continuing the hearing to have another hearing.
Correct.
So if council, and I apologize, I can't tell you what to do, but that's the applicant's desire. If council is comfortable with those two conditions, you have on the record that we will extend the clock by 14 days to the 15th of March, so the city doesn't lose ground on the 120-day period.
Great, thank you.
You're welcome.
I see your hand up, and when you give your remarks, maybe it's you, maybe it's someone else, but will you address what like a Q&A would look like, right? Because obviously there's a series of questions counselors have. We want the applicant to get answers. Would that be something where we would have ask our questions kind of here or in between and have them come back and present, or what would that process look like? But go ahead, Kelly, your hand's up.
Yeah, I mean, 14 days, realistically speaking, is not enough time. I'm just going to say that right out of the gates. I mean, we have a lot of other projects. You know, a lot of us with kids didn't have childcare at all today because all schools are canceled, and I know there's more of that happening tomorrow. It's in the world of land use, 14 days just goes by way too quickly. I'm not comfortable with committing to that timeline. If council commits to that timeline, that's fine. and we'll make it work somehow. But to adequately respond, I've already heard there's Kathleen, Councilor Walker said 24 questions. Councilor Hoganson said 8. Carl X, sorry, I call you guys by your first names. Councilor Exner said 6. So that's already up to 38. I agree with Councilor Smallwood. There'll be some overlap, but that's only 3 of the 7 of you. So I'm assuming there'll be more questions. You know, to adequately respond to your questions, we'll probably have to get attorney input also. I just don't think extending it, and I know from speaking to City Manager Wheeler, you guys have a lot of other things on your plate coming up. So just to state, oh, this is gonna kind of move everything else that you guys have already scheduled on March 1st, which I know is already a packed agenda. I don't think that's fair to your other agenda items that you already have committed to. So I would have to say that if we're gonna extend it, we need to go at least 30 days, if not more.
Okay, let's go to Mr. Robinson, then Jordan, Shelley, and then I see your hand up, Councilor Walker. I just want to kind of see what the staff perspective is here on timing. And I see you, Councilor Smallwood, as well. Yeah, Mr. Robinson.
Thank you, Mayor. I'll be brief. So I appreciate what Kelly had to say. Just a couple of things. My client has already extended a fairly lengthy, has already granted fairly lengthy extensions. We did that to accommodate the city's schedule and to try and work cooperatively with Shelley and Kelly and staff. We're not trying to be difficult, but Mac needs to know what he's going to do. And so I understand there's a lot of questions. I guess my thought is, let's come back in 2 weeks and ask the questions and we'll answer them that night. And we're all going to be there. I wasn't anticipating a lot of staff work. I guess Kelly was thinking further ahead than I was, but I was thinking we would just come back, start where we started, pick up where we left off tonight, ask us the questions. You'll have your city attorney. Our whole team will be there and we'll answer them. Then you can move on to deliberation and a vote. And in terms of the schedule, you won't have lost any time. You'll be at the same place on the clock then as you are tonight. But I don't have my client's authority to give another 30-day extension. And I want to say, my client's already extended the clock several times. I mean, large extensions to try and be helpful and collaborative. We just don't have any more time to give, Mayor, and for that I apologize. But we are willing to extend the clock, and we'll come back and spend as much time as you want at that next meeting answering questions.
Thank you, sir. Jordan?
Thank you, Mayor. We can schedule a special meeting to make more room for the rest of the agenda items. But I did have a process question, and maybe Mr. Crink can answer for us, is to help with this process and maybe alleviate some of the concerns that Kelly has. Can the council submit questions in advance to the applicant or staff so that we can see those questions? I'm guessing the majority of the questions will be for the applicant, not staff. The other thought I had too is how many are questions versus, if you saw one of the options in the staff report is, asking the applicant to make modifications to their application too. I guess that is a question in itself, but what are actually just questions asking for facts or clarifications and things that can be easily answered versus something the applicant may need more time to be prepared and to address in one meeting? Because my other concern would be that this goes on for an additional meeting, and we want to make sure if we only have 30 more days that we schedule enough time for a meeting or 2 more meetings plus the final order and everything being written and signed by a month. So those are my thoughts. Like I said, we can add a meeting, and then process-wise, Mr. Crane, can we do anything, not within the public meeting, but having questions submitted by the city councilors?
Certainly, if the plan is for the everybody to come back in 2 weeks and pick up where we left off, there's no reason between that time that the city councilors can't provide written questions to staff, who would then compile them and provide them to the applicant. I don't want city councilors communicating directly with the applicant, but if it were all funneled through Kelly, that would work. It would also give us the opportunity maybe to eliminate redundant questions or combine some and give the applicant a time to maybe be concise in their responses. So yeah, to the extent it would help streamline the process, absolutely we could do that.
All right, Shelley, I see your hand up.
Yeah, I just had the exact same suggestion as Jordan. I like being very particular with my language, and so if I'm able to answer questions in writing, that's just better for everybody. So if a potential suggestion, if all the city councilors could email all of their questions to Kelly and I, we can go through and organize them, decide which questions are questions for staff, which questions are ones for the applicant, see where any overlap is. And then also another thing that would help alleviate is if one of those questions is about a calculation or a technical thing or something that we wouldn't be able to answer on the spot, that would give us the time to be able to do that work, do that analysis, and provide an answer before the next city council meeting. So that I had the same exact suggestion as Jordan.
Thank you. Kelly?
Yeah, I'm a little disappointed to hear that from the applicants team, to be quite honest. I mean, we've been working together for a couple of years. The staff went out on a limb by giving our support for this proposal. And, you know, an extra month or two, is it really going to be that big of a deal in the end game? I mean, I just think that rushing a discretionary land use decision like this to save a week or two is a very bad idea. And I think there would be plenty of the council members on this call right now that would agree with me on that. What I also want to prevent from happening is if we get 40 or 50 questions, those questions, just answering those questions won't answer all the questions. Those questions will inevitably prompt more questions. That's how questions work. And so I want to be very open and honest with everybody that just because we answer and the applicant answers all those questions, that doesn't mean that's going to answer all the questions. It will generate more questions is what it's going to do. So I'm a little bit discouraged that they weren't open to more extension. So that's all I have to say.
We're getting to a point here where we should have just asked the questions. Jeremy, why don't you go, and then let's figure out what we're going to do. It's getting frustrating for me.
Yeah, that's exactly what I was going to say. Kelly brought up was that we're going to have more questions after the questions because, you know, I know that a lot of you will have the same questions I do, and I'll gladly give the floor to you to ask the questions, but I'm going to have follow-up questions. And I know you guys will too. I've done this now for almost 17 years on that, and that's just kind of how it happens. So we're going to have a lot more questions after we hear the questions. The other piece of it is to come back later. I know that it may be very hard for some others on this as well as the ex parte contact that would happen in between. And so the questions we're going to get bombarded by from outside this, and I don't think that's fair for individuals of us because, you know, what one person hears or gets influenced in because, you know, there's going to be people reaching out to that kind of expands on it. And so unfortunately, I think that's just part of the nature of it. But anyway, that's my 2 cents on that.
Thank you. Mike, let's go ahead and then yeah.
Thank you, Mayor. Sorry, Mike Robbins again. So we truly appreciate your staff support, but Mac wanted me to remind everyone, we've been at this since June. This is the 8th month of this application. And so we're well past the original 120-day period. And that's because Mac has been generous with extensions. We want to do what council wants. I simply don't have the authority of my client to offer more than I've offered. So, you know, I hope, I mean, either we can do this tonight or we're happy to grant a 14-day extension if that's comfortable with council and come back and spend as much time as we can with you. And I would hope folks would respect the fact that if the time to talk to council is ended, if that's the council's choice. And I think the sooner you come back and do it, probably the fewer ex parte contacts you're going to have in any event. But that's my council's direction, and we're trying to be generous and work with you. But we would like to come back in 2 weeks, be prepared to spend as much time as we need to answer your questions, and then you can arrive at a decision. Thank you, Mayor.
Thank you, sir. Councilor Hokanson, sorry.
Well, if everyone's ready, I move that we table this until a subsequent meeting, that we send our questions in to staff, and that we reconvene and continue this discussion.
There's a motion on the floor. I see a second. Is that a second, Councilor Smallwood? Okay, I see a motion on the floor from Councilor Hokanson, a second from Councilor Smallwood. All those in favor of the motion, please signify by saying aye.
Aye.
Aye. Opposed, nay, or a thumbs down? We have a nay from Counselor Sheldon. Kelly, you have a hand up?
Yeah, can we put a deadline on the questions to be submitted to us by, so we kind of, so the staff and the applicant both know kind of the timeline of when we're going to receive them by?
Sure, Counselor Smollett.
Yeah, I'd say, do we need a motion on that? I feel like 24 hours is adequate. If Kathleen and everybody already has their questions in their head, I feel like you should be able to get them to them by tomorrow. Is that agreeable?
No, that's not going to work for me. I'd like a couple days, please, because I've got some other things. Well, yeah, because I like.
We're going to ask your questions tonight. Now you need a couple days to get your questions in.
There's 7 total counselors. I mean, so how does all of council feel?
Well, okay.
I would prefer to send them in by Thursday noon or something like that.
Go ahead, Counselor Walker. You got the floor.
Thank you. Yeah, Thursdays I can work that. The question that I was going to ask originally was, can I? What I heard the lawyer say was that we could ask questions of the staff, and that was my intent, because some of my questions are a little bit more complicated, and they and I want to be able to kind of ask those of the staff. And then if they can't answer it, they can always bump that over to the counselors or to the developers.
That's all right. Tell me if I'm wrong, staff, if that's my understanding of the process, is that we're going to send it to Kelly and Shelley, and they're going to go through the questions and figure out where to go from there?
Yeah, I mean, I've never done this before, but it sounds like I think what Counselor Walker proposed is probably exactly how I would do it, yes.
Mayor, just to be clear, because this wasn't in the counselor's motion, the applicant said it would extend the 120-day period by 14 days if you continue to the next meeting, which I understand is March 2, and you picked up where you are tonight, which is questions of applicant.
Yeah.
So I wanted to make sure we were in agreement on that. Is that?
My understand, I am in agreement with that. I believe our council's in agreement with
Thank
that.
you.
The only question I have for staff on that is, last time we were in this kind of a process, we had an issue where we had to reopen the public hearing. We would not have an issue. I don't mean like the public testimony portion. Are we looking at anything like that in this, where we would have to back up the process? Or are we going to be good just opening it right here?
Mayor Pulliam, no. In fact, before you adjourn this evening, you may want to go ahead and close the record for public testimony and limit the discussion in 2 weeks to exclusively questions of the applicant and staff, but with no new evidence admitted into the record.
Is there any counselor has a problem with doing that motion, just taking care of that right now while it's top of mind?
Can you just clarify for me? I don't have a problem closing the public testimony, but additional evidence is.
No, if you allow new evidence, then you have to reopen the record to allow everyone an opportunity to respond to that evidence, and that just continues the discussion.
But answers to questions, is that new evidence? I'm sorry, I'm new at this.
No. So as an easy example, if there's a traffic study in the record, you can ask questions about the traffic study till the cows come home.
Okay.
And those questions do not constitute new evidence, because the evidence is the traffic study that's already in the record. So you can ask questions as long as it doesn't require the applicant to put new evidence in the record. We can talk all we want.
Thank you.
Councilor Sheldon.
Yeah, I want to explain my vote. I want to make sure we're being really cognizant of Kelly and the planning unit's time. This is like, I'm just really struggling a lot with the extra burden of work that we're going to put on him to sort questions that could be duplicative, that could be sorted out via a conversation, that are like we've already discussed, that are just going to lead to further questions. I don't want to be here till midnight either. I got to get up at 4:30. But I also want to be respectful of the people that are coming to work for us and their time, and be able to do this the right way, so we don't end up with predicaments that we can't enforce later on, is another concern.
Let's go Councilor Peetzold and then to Shelley.
Yeah, I appreciate that, Rich. I agree. I think the way this has been done in the past, for me, I mean, it doesn't have to be always the way it's been in the past, and that's not my point. It's just the experience I have is this is weird and unique that we've ever done is submitting questions. What would have happened when I was on planning and all those other things was we would go and come back at another meeting and ask those questions and not have anything submitted for someone to prepare. It's that conversation. We are going to have those questions coming back. And so, and then we would close the public meeting, but then we would still be able to converse with staff, is how it's been done. And so go right into that right after we then close it from close the public meeting, or you know, the process there. So we still have that whole process to go through. So in the past, not saying we have to repeat the past, I'm not saying that, but is we would just close it and then bring it back up at the next minute, not submitting questions to anyone, and then the process is completely I think fair as well, but just my opinion on that.
Thank you. I've seen Kelly's hand up, and then we'll go to Shelley.
Yeah, I just want to be very clear that I don't think you guys have committed to a meeting date, and I don't think you should. The applicant has extended the 120-day clock by a certain amount of days. You're under no commitment to go with whatever day that Mr. Robinson's suggesting. You don't even have a meeting on March 2nd, so that's the day he threw out there. You already have like 6 or 10 things on your March 1st meeting that I'm sure will take a lot of time, and Jordan and the rest of the staff has been laying out for months now. And I really appreciate Councilor Sheldon's comments that staff does have a heavy workload, not just my department, every department. And I don't think everything should just get pushed aside because the developer wants to meet on a certain night. You know, if they want to only extend it by that many days, that's fine. But I think you should pick a night tonight that works for you guys, not for the developer. And the developer needs to find a way to make it work that night. That's how I feel about it. March 1st, you guys already have a heavy agenda. I wouldn't even consider that. And I wouldn't consider back-to-back night meetings either, because March 1st, you'll probably go for 3 hours with how much stuff you have on there. And I think it would be unfair to all of you as volunteers to come back the next night for another 3 to 4 hour meeting. So I'd pick a night that works for you. I wouldn't, they've extended it by a certain amount of days. Now pick a night that works for you guys.
I'm going to go to Councilor Hokanson before, I want to get some preference to councilors. Councilor Hokanson.
Thanks. I just wanted to point out the motion was on the floor, it was seconded and voted on, and we've now kind of ignored it.
No, well, no one's ignored it. I mean, I understand why you would say that. I'm still going with it, Counselor.
I agree. I just, for staff and everyone else, the motion was carried, and we need to move on now.
Yeah, I agree. Let's go to Shelley and then Mike, and then let's try to get this going.
I'm sorry, I was actually just going to bring up this motion, same exact thing that Councilor Hokanson said.
Thank you. Mike?
Thank you, Mayor. My apology. We're not trying to be difficult or combative. My client's offer to extend the clock was contingent upon 2 things. The next council meeting, so if you want it, just as long as it's not more than 14 days, it's ultimately council's choice, but it was contingent on the next council meeting and contingent on picking up where we left off tonight. And if for some reason council doesn't want to do that, it's your call, but then my client would tell me to tell you we haven't extended the clock. So we're not trying to be difficult. We want to work with you. I appreciate everything that you and your staff have said. We hope you can, you're right, you've got a motion. So pick a night in the next 2 weeks. We'll make sure we're there. We will limit our answers to evidence in the record, and we'll do our very best to answer your questions.
Thank you.
Thank you.
Yep. All right, so let's move forward. Chris, I mean, what do you recommend we do at this point as far as, do we want to close out the public testimony portion of this?
Right, so a number of things. First, before we leave tonight, I think you should close the record for public testimony. You have an extra 14 days. Pick a night that everyone can get back together and have a couple hours, and set aside a couple hours for questions on this. It doesn't have to be the next council meeting. If I heard Jordan correctly, he said you can always schedule a special meeting. But it's got, we have to have a final written decision by now, what, the 15th or so of March. So pick a night. And then third, following up on Council President Pietz's comment, there's no obligation. If somebody wants to wait and just hold your questions for a couple of weeks, do that. If you feel like there might be some benefit in getting them out to staff and the applicant beforehand, you can do that too. That might speed questions along, reduce duplication, increase efficiency, whatever. But there's no obligation to put your questions in writing and submit them to staff in order to ask questions 2 weeks from now, or a week from now, or 10 days from now, or whatever it is. So pick a date that works. Just make sure we can meet the 120-day deadline, close the record for testimony tonight, and anyone who wants to submit questions in advance is free to do so.
Great, thank you. Do we have a motion to close the testimony? Councilor Exner?
I move that we close the public testimony.
Is there a second? A second by Councilor Walker. All those in favor signify by saying aye or give me a thumbs up. Aye.
Aye.
Opposed, a nay or a thumbs down. All right, motion carries. Let's move on with the agenda. It's been so long since I've looked at the agenda, I can't find it.
Mayor?
Yes, yes.
We need to set a date right now so that we can get that public notice.
Oh, pick a date. Thank you. Yeah, all right. Do we have any idea on the date?
I move that we meet again on Monday, March 1st at 6 p.m. Take over our working session and move right into our council meeting if needed.
I think we got to assume this is going to take longer than an hour for sure.
I do too, and
let's just start at 6.
So we have a city council meeting that night, right? Yeah. We gotta eventually figure out our work session on work session. I mean, we got to figure out what our work session calendar is going to be. You know, what major items are going to be prioritized in the city. I don't want to bump that. You know, we keep kicking that meeting down the road, and I'd hate to keep kicking. I'd rather pick another night to tackle this issue, to be quite frank.
The alternative is the 2nd. Tuesday night.
Tuesday the 2nd.
Just for clarity too, if you guys continue it at a hearing like you're doing tonight, we don't have to mail notice unless you want us to. You please let us know if you want us to mail a notice out.
So I modify my motion. Propose Tuesday night, 6 o'clock, March 2nd.
No, that doesn't work for me. No.
That's just meeting after meeting after meeting after meeting for me. So each night of the week, I would say that the agenda on Monday would need to change and put this as on that agenda on Monday. Sorry, but the agenda has been laid out, but it hasn't been, submitted out there. We've done in the past for those things that needed to hit the 120-day clock.
So I submit Monday, March 1st, 6 p.m. again.
Real quick, Jordan, did you have a quick comment?
We can push items to the next week if the council wants to meet, March 8th or at a meeting in March.
Okay. Go ahead.
All right, so let's make the motion that we meet again, continue this meeting on March 1st, 6 p.m.
Well, March 1st. I don't know if it has to be the very first thing we do at 6 p.m. because that's a work session time. We may want to put it on the council agenda at 7, but
as modified, March 1st.
Yeah, March 1st. Yeah. Okay.
I'll second that.
All right. There's a motion by Councilor Hokanson and a second by Council President Peetzold to place this on our city council agenda on March 1st. All those in favor signify by saying aye or provide me a thumbs up. Aye.
Okay.
Opposed, a nay or a thumbs down. All right, motion carries. Moving on. All right, nothing else we got to do on this one, right, guys? We're good, everyone? Okay, we're good. All right, report from our city manager, Jordan.
I want to give you a long report. I'm kidding. Council, you are busy, and the goal setting, I think, went great. Thanks again for those sessions. 4 meetings, 3 of them, visioning, goal setting. We're looking forward to bringing back your goals for adoption at a meeting in March. We'll be working with Sarah on refining that vision, and then the goals. So thanks again for that. It will be busy, and I'll talk with the mayor about the schedule going forward and looking, probably adding, at least another meeting a month for a couple months is probably one of the options, like we did a couple years ago to handle some of these work sessions and other items that are going to be ahead of you. Really quick, the one thing I did want to bring up is the vehicle registration fee. I sent an email, my weekend update about that. We had a heads up from the county that the Clackamas County Board of Commissioners will be having a work session or a policy session about the VRF on February 23rd. And there was some chatter from the cities in Clackamas County about this and the opportunity for or the potential that it could be repealed. So some cities are submitting some comments to the county or writing letters because they're in similar situations that we are. This VRF, the vehicle registration fee, is one of our 2 funding sources for the 362nd and Bell Street project that will be using that revenue to debt finance that project. Without that, I think our calculations right now will be about 100,000 short for the debt. So we do have other options, you know, for closing that gap. But I wanted to get the council's temperature if there was interest, if you wanted us to draft a letter or take a position on this or not take a position at this time. But I thought it would be prudent, given the work session is next week, to have this discussion. So any thoughts, any indication? Should we draft something? Is council interested in weighing in on this, or should we wait and see?
I'll just weigh in with my thought. Of course, we all have our own individual opinions, and I'll be open to any. But on mine is I would look for a non-opinion, non-stance, no letter on this issue. You know, vehicle registration fee, the commission passed it. We're getting those funds. We're certainly going to put it to best use in our community. Once those funds come through, we'll allocate them correctly. But it should be noted that this was just on the ballot not long before, and it went down resoundingly in this county and in this community. So we should be a little bit aware of that when we're, you know, actively trying to advocate for the commission to do things. But that's just my opinion. I'm totally open to others. Councilor Exner.
Yeah, the previous council was, I think, unanimous, maybe most of us, against the VRM. And I know it was very much that way with a lot of the different people that I talked to. So I would be in favor of no comment.
Councilor Walker. You're muted.
I'm a little bit confused. So did this pass statewide, but it did not pass on Clackamas County, or is that how that? Yeah,
Councilor, so what it was is and I can't remember the exact language of it, is they basically went for an opinion from Clackamas County, from the voters. They put it on a ballot and it went down. So this was just a county election that happened. Of course, this is a county vehicle registration fee that was passed by the Clackamas County Commission, I think sometime about a year and a half ago. And now with the new counselor, now the new commissioners on there and the new commission leadership, they're talking about repealing it.
Okay. Well, they're also talking about the fact that we need to add more roads out there. So I'm just trying to understand where they plan to pay for those. But you know, nobody wants to be paying more for their vehicle registration, but we all want our roads taken care of too. So it's a conundrum. Thanks.
Thank you. Appreciate it. Any other comments? Okay. Yeah, Jordan.
Okay. We'll hang tight. And then, you know, we did have this storm. I'm sure we're all thawing out now and getting around. Sandy, you know, was spared the worst of the ice storm. We still had some ice, obviously a lot of storm. We had crews running 24 hours a day, a couple trucks every day, around the clock. Of course, you know, we do, you know, struggle to get to every single neighborhood street. We're taking calls and emails and requests for those neighborhood streets. The major roads are plowed, but I know there's a lot of streets that didn't quite get there. And, you know, we're always looking for improvements, how we can communicate better, get those requests in so we can adequately plow those streets. But the police department and CCOM in particular, in routing those calls, had numerous calls, I think record volume of public assistance requests. you know, Sandy, fortunately, in the area code did not have a lot of power outages like some other parts of the metro area, but there was a lot of public assistance calls for outages and needing help getting out and things like that. So I just wanted to say thanks to our police department, our public works department. SandyNet too had, fortunately, internet was mostly spared as well for our fiber customers. A couple of the towers did go down with outages, but yeah, again, I think I jinxed it this year, because when we talked, or this over the last 360 days at least, with the pandemic, wildfire, smoke, I was like, we're gonna get a blizzard. Well, we came close. So I'm gonna stop talking about natural disasters and other things, but I did want to just say thanks to staff for that, and for all their work on working around the clock to try to keep the community mobile as much as possible. When you get this volume, it's really hard to get those roads cleared and adequately traversable. So that's it for me. Thanks.
Thank you. Let's go with Councilor Sheldon.
Yeah, for brevity, I'm going to keep it super short, but hey, I just have a quick question. So with the governor's lowering of the COVID stuff, is there going to be any changes to our city hall, the opening of it, any projected programs specifically like with our seniors that might be changing in the near future? Any thoughts, discussions about that? And that's really all I have for right now.
Yeah, happy to answer that. On the seniors, the struggle there is that the guidance currently doesn't allow for senior programming or senior centers specifically to reopen under any of these risk levels. So we're going to continue to just watch that and do, as much as we can in terms of the outreach and client services and Meals on Wheels. The library will be opening March 1st, and we're preparing plans for City Hall as well. So we're getting to that point. To start opening in some capacity to serve the public. But yeah, the community center is a tough one given the population that's served, but we are looking at what we can do to open for programming for rec programs and other enrichment programs at the center starting this summer. So we'll continue to work on that.
All right, thank you. Councilor Exner.
I have no meetings to report or anything. I just want to say thumbs up to all the public works folks that cleared our roads. And I got to tell you, our internet is superior. I have talked to several of my family members up and down the state, and they did not have nearly the stuff that we did. And I appreciate that. So, and that's it for me.
Thank you. Councilor Walker.
Hi, I don't have anything to report. I was assigned to do the library liaison, and I haven't got to their meeting yet, so I'll start kind of engaging in that. I do kind of plan to be, I wasn't assigned, I asked to be, but I wasn't assigned on the planning and the economic development, but I do plan to be involved in those. And just because I think there's some opportunities there. The homeless bill that Representative Kotek is introducing has not had a hearing scheduled yet, but it's, if you guys all want to take a note, it's House Bill 3115, and it's decriminalizing homelessness, but it's got some real interesting aspects to it that kind of concern me to some extent. So I'm so thankful that Rich is going to be taking up that that aspect of a need of our town there on that task force. I want to make sure when we're doing these task force, which is great, is that we do have the agendas and the meeting minutes for those, and that they are, noticed on our public website, and that, people can access them and get the minutes. I know I talked to one of the members of the Economic Development Committee, and who had said that they didn't usually have agendas or minutes. So that's something that I think that is really going to be helpful to kind of track the progress there and keep everybody informed. So I really look forward to that. I really appreciate, again, all the work that the city staff has done on tonight's meeting. There was a huge amount of information to put together, and of course those PW folks really really rocked it with the storm in the parks. I did report some downed trees on Tickle Creek Trail and over by Timberline Park. And Joe got out there today and took care of most of them. I think they're waiting for a specialized faller on one pretty hairy cedar. So, yep, thank you.
Thank you. And Councilor Hokanson.
Hey, I'm tired, but thanks you guys for being patient with me. I just, Mayor, want to know what our plans are for creating some of these new committees, or when they're going to get their actual start, like wastewater and aquatics and things. Is that on our, coming up soon?
To the chair.
So I can just do it?
Yeah.
Right on. I'm on it. Thank you.
Yep.
I feel so empowered.
I mean, that's the whole point of these committees, right? I hope that all of you saw with the committee assignments, I really try to think through, skill sets and interests and those kinds of things. But, we're a team, and I view those council liaisons as you're a liaison from our city council team, right? And so you're empowered to run with those and to be, our voice and ears on those committees. So thank you. With that, Councilor Smallwood.
Had a Parks meeting last week. It'd be the first meeting for all the new members, and it was pretty much just kind of a, here's the rules, here's how we act, this is what we're looking at, here's the master plan and whatnot. So just kind of getting their feet wet. So that's pretty much all I've got to report. I did want to address, though, something in regard to earlier this week. So, there are 7 of us on this council, and we determine goals, and we act as a singular unit, like Councilor Hawkinson mentioned earlier. And regardless of whether you agree with things or not, no individual councilor has the right to speak for council to go before the legislature discussing council business and asking for funds. That is not appropriate. So I just want to address that, get that out in the open, and hopefully we can move forward.
Thank you, Councilor. Appreciate those comments. Councilor Peetzel.
Yeah, I just want to thank the Public Works. They did a great job. I know it's been said a few times, but we've had, we don't get big storms like this very often. But I did want to ask Jordan, because it's been a while. Back in 2007, when we all had 3 feet of snow out here, and I was just on the council, we kind of realized we couldn't keep up. And not that we couldn't keep up this time, it's just we want to make sure we're prepared. And so sometimes the plans we've had in the past sometimes just don't transition over the years and years. And at that time, we realized that we could reach out to a lot of people around our community that had skid steers, bobcats, those type of things to help out in that scenario if it happens. And so I just want to bring that up, make sure that that list has been updated because it can get forgotten about sometimes until it's too late. And we're in that situation before. And what we did back then was just afterwards, we realized we need to have a list. And then we had a lot of people out there willing to come out, help, and, they'd get paid whatever to come and plow some of our streets if, we couldn't keep up. So, but the guys did great. I mean, I sat here and watched them go up and down my road many times out here. And I know I live on a little more busier road than some of the other ones that didn't get it as much, but just appreciate them working all through the night and so we can stay safe. So that's all.
Thank you, Councilor. So first, just thank you to all of our city staff, Public Works, police, everyone. Obviously everybody's jobs, Sandy Net, everybody's jobs get a little bit more difficult during winter events and events like what just occurred. Obviously, we've got busy city council meetings tonight and further's coming up. I'll talk to Jeff and Jordan and see if we can identify kind of a third night, at least for the time being, while we're tackling some of these bigger issues. One of the reasons, Don, when you talked about the last work sessions, one is we got to prioritize these work sessions, right? And I really want to do that, council rules being one of them. But the other thing I really want to discuss probably on the last kind of part of that work session is we really do need to discuss the legislative session that's going on. listen, we just all went through our goal setting together. And I hope that the realization coming out of that is that we are very much on the same page, especially with looking at a lot of these priorities that we have as a city and these issues facing us. There's no doubt in my mind that anyone singularly sitting in front of any representative or senator is going to be pushing forward those items that most of us or all of us agree on. I think some of the consternation may just come with the fact that there's a little bit of strategy that's involved in some of these things that, I think all of council would like an opportunity to all come together and talk about. For example, in that last legislative session, we advocated for that 500,000 green alternative analysis that ended up with, with us all kind of walking around with trackers that day. That was the only thing we had asked for out of the legislature. And I'll never forget being in I think it was a van we had that day or something. And we were talking about what we were going to lobby the legislators about. And Councilor Exner, God bless him, he had like 20 items, on that list. I mean, the guy was ready to go. But we said, whoa, stop, Carl. Sandy's only 11,000 people. We're only so big. We're only going to get, so much. And when we look at the legislative session coming down the pike and the lottery machines and COVID and what that fund looks like, we're even going to have to be even more nimble and focused in what we ask for. And so let's just, kind of put any kind of negative feelings or whatever as to anything that might have happened behind us. And let's try to get together as a council, in that work session towards the later part of it, and just real broadly come up with, what we really want to be advocating for, when we're making funding requests and making those kinds of requests in front of our elected representatives in the legislature. So that's where I would look to, take that discussion with our council. And I just wanted to say that tonight is I really believe we're all on the same page, and at least vastly on the same page. And what we're really looking for is just an opportunity to sit down and strategize together so that we can get to those end goals together as successfully as possible. So with that, this long-winded mayor will be quiet, and I'll go ahead and close out our meeting. I'm sorry, I didn't see your hand up, Councilor. Yeah, go ahead.
Yeah, I just want to have the opportunity to respond. I appreciate the comments. I understand the consternation about the fact that when Anna Williams reached out to me and asked to meet with me, first of all, I told Jordan about it and didn't get any feedback like, no, I shouldn't do that. So that was like over a week before the meeting. And I got the priorities that you all decided back in August before I was even on board. And then, the most of the meeting was just that $14.7 million letter that you guys signed in January when I was in place. So that was what most of the discussion was about, the need for that. So I wasn't out going rogue, so to speak. And I appreciate the opportunity that we have coming forward to talk about. There is no current rule or council rule that says that, I can't go talk to somebody. If I'm more than willing to kind of, let's all get on the same page and follow the rules if they're there. That's my intent. That's going to apply to all of us. And so that's where I am concerned that, we have I hope we have a good chance of getting the $14.7 million. I do have concerns that, when I'm hearing, talking about our state legislature and our governor, attributing it to Sandy, it does make me concerned for our reputation. And I think those are all things that we can talk about in the council rules and get to some agreement. And I'm looking forward to that. I think we all need that for, to trust and have, mutual trust and acceptance and support for everybody. So thanks for saying that, and let's go home.
Thanks, Councilor. The only reminder I would say at all in response to that is I'm not quite sure there was a successful legislative ask financially that has come out of the legislature in the last 25, 30 plus years for the city of Sandy until the most recent last 2 years in which I've made that a priority and actively went after those funds, plus many, many more additional funds. And so we can kind of point towards, things that I may have said as mayor that might have said a governor or whatever else, all of which was always me solely, as the mayor, separate from city council. But I would also argue that the only reason, I will say, the only reason this 14 million is even an opportunity and even on the radar screen is because I made it a huge priority when I was sworn in as mayor and brought it up at our council goal setting 2 years ago and pushed it really hard. And I'm proud of those facts. And I'm remiss to say it's a little disappointing to hear that my successes are now brought up as potential failures moving ahead, because I put a lot of work and I believe deserve a lot of credit for what we were able to do for this community. So yeah. All right. Thank you, everybody. I'm going to close out tonight's meeting. We'll all talk soon. Thank you.
Thanks. Night.